list. Yes.
Urgent application relating to
Maybe-
second
Application for
in connection with the second
yes,
application.
Lordship may be permitted to mention for inclusion.
inclusion for
Hearing matter.
yes.
Hearing matters.
Hearing of what? Claim case or second appeal?
Second appeal.
Okay. After 2 weeks. Yes.
May I be permitted to mention for application under section 5?
Yes. Give it. Yes.
In the list, my lord, item number 45.
Yes. Is outside the list first.
My lord, for inclusion, my lord. Second appeal for inclusion.
Okay. After 2 weeks.
Your Lordship, may I be permitted to mention a second appeal for inclusion in the list?
Second appeal for ready for hearing.
Hearing.
Yes. After 2 weeks.
My lord, may I have you kindly to mention one restoration application for inclusion, my lord?
Yes.
Much obliged.
One application for filing paper motor accident claim cases. Let it appear.
Yes. Yes.
My lord, an application for substitution.
Yes. Give it.
Chain matters, further to be mentioned, have been reached to your lordship's court, my lord,
Do we mention?
month of November and December. And my lord, at least, my lord, 3 or 4 occasion I mentioned that the matter may be placed, my lord, as to be mentioned.
No. No. Matters are ready for hearing.
Yes, earlier days.
Paper books.
Paper book file.
LC trial court records have come.
Yes.
So let it appear for hearing after 2 weeks. Yes.
My lord, earlier occasion, your lordship.
No.
Say
Let it appear for hearing. Okay. Category of hearing after 2 weeks.
next week.
No. After 2 weeks, all hearing matters will be
Earlier
available.
occasion, this matter was mentioned. and
Yes.
your lordship
Now it will be.
The matter.
Now it will be clarified. It will appear after 2 weeks under the heading hearing. Yes.
Your lordship for second appeal hearing.
Second appeal hearing. Yes. After 2 weeks.
Lordship may
Yes. After 2 weeks.
Not-
Yes. Paper books are ready.
Yes,
Trial court records have come.
I don't know. I am not. I have to file very soon. I am the.
Okay.
Lordship, urgent consideration of the stay application is required.
Yes. Give it.
I have Lord's leave to mention 4 motor accident appeals for filing paper book.
Filing of paper books.
It is or convention of delay.
Okay. To be mentioned. Yes.
Well, item number 45, well, it's a to be mentioned matter. Well, lordship, well,
45 it will be taken up.
only today, lordship will not take it, well.
No. Question is, what do you want? An adjournment?
No, not adjournment. Well, only one record, my lord. Only, my lord, title suit 4858 has been recorded. It has been 485. That is the only record. Well, otherwise, trial court records are not
Item. Which item? That is
45 for
45.
correction. Well, only well, one digit is well, correct and nothing. Well, the lower court records are not coming, well, for that.
No. Question is, it is kept for as to be mentioned for
Correction, yes, well.
correction of any order.
Lordship will kindly see একবার একটু জজ সাহেবকে অর্ডারটা দিন একটু 1 সেকেন্ড অর্ডারটা দিন
No.
well only this portion is required to be corrected
Anyway, tomorrow it will
well only
take
this
tomorrow.
portion is required to be corrected
Whatever it is, actually, I have given one indication. No, it is better that I
well,
take it
nobody
tomorrow.
appeared well till date well because the trial court records are not if a lordship can pass the order
Anyway,
itself
Acha, let it appear tomorrow. Item 50. Item 40.
5
Let it appear tomorrow.
yes well only one digit has to be corrected
Yes, let it appear tomorrow at 4 p.m.
section 5 application
Yes.
হ্যাঁ ওটা একটু ফিক্স করে
Time fix করে।
ট্রায়াল কোড রেকর্ড আসছে না তার জন্য আটকে
I am for the appellant, my lord. I am filing the paper book. Separately.
Item 11.
Paper book.
Yes, trial court records have come. Now,
The case
department
of
has
2005. The
Acha.
case of 2005, my lord.
Yes, record and order. Learned advocates for the parties are present. As the matter is ready for hearing and the paper books filed, let this matter appear for hearing at a short date din. 28/7/2026 at 12 p.m.
একটু পরে সেকেন্ড হাফে হলে হবে।
সেকেন্ড হাফে ফাঁকা আছে দেখুন তো।
But 27 বা 30th.
So it's an old matter, it has to be taken up early. 28 quarter at 2 p.m.
2 p.m. all right.
My lord, in 12, I beg to appear on behalf of the respondent.
You are the railway
Lord,
authority.
My lord, I am
You are
for the
for-
railway authority.
Yes, yes.
My lord, last date the order was passed that the paper book has been filed, but it has not been served upon us. So, my lord,
Who is
can't be
appearing
done
for the appellant?
as a direction to serve upon us a copy of the paper book.
Yes, record an order. Learned advocate for the respondent. Yes, you are for?
I've been instructed by Mr. Shujit Shah's clerk that he has still not reached the court. So I'll kindly adjourn this matter forward.
Okay, I'm just making it not today. On the
My lord, that order, my lord, they will serve. Nothing will happen, my lord.
Not in these matters.
Maybe.
Well,
The paper book has to be served on us. Whatever be the
Yeah,
reason.
let this matter stands adjourned till learned advocate for the respondent is present. The matter stands adjourned till 28/7 to 29/7/2026. না না এটা ফিক্স করছি না. Let this matter appear on 29/7/2026 under the same heading. The paper books in the meantime be supplied to the learned advocate for the respondent.
Item
Yes.
15, my lord, I am for the appellant. There is an instruction from the insurance company to withdraw the appeal. This is-
Yes, record an order. MS Gopa Mukherjee, learned advocate for the appellant insurance company, submits that she has instructions from her client to withdraw the instant appeal. The copy of the written instruction is filed by the learned advocate. In the facts and circumstances, this appeal, FMAT 1638 of 2009, stands dismissed for non-prosecution. Interim orders, if any, stands vacated. The copy of the written instruction filed be kept with the record.
No, my lord, the claimant respondent may be allowed to withdraw the amount which has
Okay, the
stated in the employees compensation code.
okay, the claimants, respondents are permitted to withdraw the compensation amount deposited upon compliance of necessary formalities.
I'm grateful. Item 14 also, my lord, I have instruction to withdraw the appeal.
Same order?
No, my lord. There was an execution case, my lord. This is the order and they have withdrawn the, they had attached the bank account and they have taken the
Yes, record an order.
total amount.
MS Gopa Mukherjee, learned advocate for the appellant insurance company, submits that she has instruction from her client to withdraw the instant appeal. Stop. The copy, in the facts and circumstances, this appeal stands dismissed for non-prosecution. Interim orders, if any, stands vacated. The copy of the instruction be filed by learned advocate be kept with the record.
Whatever amount has been deposited in 5,83,560 along with accrued interest may be refunded to us.
Okay.
Because they have taken the amount from the tribunal by way of execution.
It is submitted by learned advocate that the award is already executed before the learned trial court. Thus, in the facts and circumstances, the appellant insurance company is permitted to withdraw the compensation amount deposited before the Registrar General, High Court, Calcutta, upon compliance of necessary formalities and upon issuance.
My lord, I will file the withdrawal application only.
No, withdrawal application.
I will be refunded.
Yes, upon compliance, whatever you have done, upon compliance of necessary formalities and upon prior notice to the learned advocate for the claimant. You can serve notice and withdraw.
My lord, they have already taken the
No,
amount.
because after all, I am passing an order to permitting you to withdraw. So you serve notice.
So withdraw. ইয়েটা মেলটা
15, my lord. Kindly fix it at the first week of the August at 2 p.m. Matter was partly hard, my lord, partly hard. It was.
Yes, record an order. Learned advocate for the parties are present, as the paper books have been filed and the trial court records have come. Let this matter appear on
First week of August.
huh?
সোমবার তো বাদ দিয়ে
Huh?
জুলাই কি না না ফার্স্ট জুলাই আগস্ট
Acha, third 3/8
4th 5th 6th 7th
Acha 4/8/2026 at 3 p.m.
my lord 3 p.m. my lord ঠিক আছে 2 p.m. my lord 2 p.m.
It will require more time. How much time?
জানি না অনেকদিন বয়ে আচ্ছা হ্যাঁ ঠিক আছে রেখে দিন
Okay, 2 p.m.
ঠিক।
Acha 3 p.m. করে দিন ওটা 3 p.m.
ঠিক তো হ্যাঁ চলো
I am for the appeal, my lord.
Yes, who is
Is it-
appearing for the
Case of 2008, my lord.
anyway, not today.
The case of 2008, my lord.
Yes, you are appearing.
no no
Let it be not today.
My lord, I pray for extension of time to deposit the award check.
Item 17.
7.
Yes, record an order. Mr. Pahari, learned advocate for the appellant insurance company, prays for time to deposit the compensation amount before the Registrar General High Court, Calcutta. Thus, the time to deposit the said compensation stands extended till 27/7/2026.
Mr. Karim for respondent insurance company হ্যাঁ ঠিক আছে for respondent insurance company not
No, no. Okay. Acha, respondent insurance company.
I am for the appeal मैं appeal
আচ্ছা
না বলতে সঙ্গে সঙ্গে চলে যাচ্ছে
Thank you. 18, yes.
Order dated 24 April 2020. Matter was heard.
not hard, my lord. It was
এটা লেখা আছে heard the learned advocate. Now, my lord, this is the appeal is by the claimant for the matter against me, and one appeal filed by the insurance company for not paying the matter the compensation. Compensation difference is another issue. This is the matter short matter, matter. I mean, the earlier occasion, your lordship fixed the matter on 18 May 2006 at 2 p.m. This is the order on the time. Next to the job site. Kindly fix it at matter short. Din na job site ta dekhe.
Anyway, learned advocates for the parties are present. As this matter was heard earlier, let this matter appear on 29/7/2026 at 3 p.m.
28.
27/8 or 28. 29 বললেন 29/7/2026 at 3 p.m.
under section 163A, my lord.
এদিকে আসুন এদিকে আসুন
20, yes.
my lord this is a I'm for the
This is for enhancement.
No,
Then-
dismiss.
Dismissed. Okay.
my lord I'm for respondent I have a can that name change my lord because Reliance
What is the, let me see the application. Can 2.
can
Hey, can 2 application টা দিন তো।
ঠিক আছে
Okay. Learned advocates for the parties are present. The application Can2 of 2026 filed by the applicant is taken up for consideration. This application is filed by the applicant with a prayer for substitution. Stop. It is the contention of the applicant that the respondent Reliance General Insurance Company Limited is merged with Inda Sindh General Insurance Company Limited. The applicant herein. Stop. The applicant has annexed copy of the certificate issued by Insurance Regulatory and Development Authority of India. Upon perusing the petition and the certificate issued by the Insurance Regulatory and Development Authority of India, this application stands allowed. Let the name of the respondent number 1, Reliance General Manager, Reliance General Insurance Company Limited, be deleted from the cause title, and the name of the applicant, Inda Sindh, UNDUSIND, General Insurance Company Limited, be incorporated in its place and stead. The amendment be carried out by the department within 2 weeks, liberty to mention. So after 2 weeks you mention it will.
Matter was fixed on 14th, my lord. 163A matter.
On which date?
On 14th of this month.
Achha. So let the amendment be carried out. Thereafter I shall take it up. আচ্ছা 2 weeks পরে কবে থাকছে দেখুন তো। কি 6 তারিখে? Let this matter appear on 6/8/2026 at 3 p.m.
I'm grateful, madam.
I am for the appellant.
Respondent.
You are for the insurance company. The matter was heard earlier. No, it was heard earlier. It may.
No.
Acha, record an order. Learned advocates for the parties are present.
It will be
As this matter was fixed earlier, let this matter appear on 30th July 2026 at 3 p.m.
30th.
30.
I am for the appellant.
Respondent number 1.
The matter was fixed on 9 July at 2 p.m. But due to bar resolution, this matter could not be taken up.
Yes, record an order. Learned advocates for the parties are present as this matter was fixed earlier. ওই 30 তারিখে দুটোর সময়। আচ্ছা, this matter was fixed earlier. Let this matter appear on 5/8/2026 at 2 p.m. 5th of August.
4th of August, you will also fix this matter. But since I have given the serial number, wrong serial number, thus the matter came out to be mentioned.
So let it appear on 5th of August. 5th of August, you have any difficulty?
No.
5th of August 2026 at 2 p.m.
Right.
Item 20. Yes, not today.
Milord, 24 with 25. Milord, in this is a disposed of appeal. Milord, there are 6 claimants, but Milord, somehow in the order sheet, Milord, the claimants number 1 to 4 have been made in title 2. 5 and 6 have been Milord omitted. Maybe a typographical mistake.
Appearing in the cost title.
Yes, my lord.
Milord, cost title. Milord, your Lordship will kindly say, Milord, the order dated 3rd of April
No, June 29, 2026.
My lord, that is the disposal order. My lord, in
Yes.
disposal order, my lord, page number 4,
Page number
or
4.
rather page number 5.
Page number 5.
Page
Yes.
number 5 at the top.
Yes.
My lord, heard learned advocate for the appellant insurance company and learned advocate respondent number 1 to 4. Claimants. My lord,
Yes,
it
so
should be, my lord,
operative portion has to be changed.
my lord, yes, it should be, my lord, 1 to 6, my lord.
Respondents 1 to 6.
Lordship, 1 to 6. এটা operative portion টা
Yes.
এখানে ভুল আছে 6 জন পাবে
Respondents claimants number 1 to 6.
1 to 6, my lord. In all places, my lord, where it is 1 to 4, it should be 1 to 6.
Yes, record an order. Learned
More importantly, my lord, at page number 15, that is why the trouble is.
Yes, operative portion.
Lordship, I'm grateful.
Learned advocates for the parties are present. It is submitted by the learned advocates that in the judgment and order dated June 29, 2026, instead of respondent claimants number 1 to 6, it is mentioned as respondent number 1 to 4. Stop. In the facts and circumstances, the operative portion of the order in page 15, second paragraph stands altered. Instead of second paragraph of page 15 of order dated June 29, 2026 stands altered and clarified. And instead of respondent number 1 to 4, it shall be recorded as claimant stroke respondents number 1 to 6.
Not in first paragraph also.
Similarly, in all other paragraphs, instead of respondent number 1 to 4, it shall be mentioned respondent number 1 to
Extremely
6.
grateful.
Other contents of the order dated June 29, 2026 remain unaltered.
Grateful to your lordship, my lord. It is railway claim, my lord. Other side here also.
26. Yes.
Maybe disposed of several times, it was fixed, my lord. But
Paper books are ready.
yes, sir.
No, it is it an appeal or a revisional application?
Appeal.
Appeal against the interlocutory order, final order. Yes, record an order. Learned advocates for the parties are present. As the matter is ready for hearing and the paper books filed, let this matter appear for hearing. Huh? Yes, 1st August 2000.
Any day after 5th August.
আচ্ছা 6 তারিখে দেখুন
At 3 p.m. Sorry.
6th August 2026 at 12 p.m.
For the appellant, initially this matter was dismissed for default. Your lordship was pleased to restore the same and fix the matter for we mentioned for fixing a date. Paperwork has already been filed.
Who is for the other side?
HON'BLE is appearing for the.
Anyway, then let it be not today. In his presence, I shall fix.
Only fixing a date.
Whatever
I will
it is.
intimate him. Only fix a date. I will intimate him.
Yes, learned advocate for the appellant is present. As this matter is ready for hearing and the paper books filed, let this matter appear for hearing on 3/8/2026 at a time টা দেখুন তো 3 তারিখে anyway 2 p.m. Now revisional application 12:30 থাক at 12:30 p.m.
I'm grateful.
28, my lord, we have already submitted the cost, my lord.
Let me see the order, last order. Have you filed the cost receipt?
I should file the affidavit of compliance in due course of the day, my lord. Otherwise, my lord, if
No, do you have the receipt showing payment of costs?
I don't have it.
Anyway, I'm making it not today. Come ready tomorrow or on the next day with the affidavits.
Tomorrow, my lord. Grateful.
29, my lord. I have filed one application, my lord. Not filed application. This is for extension of time to deposit the awarded amount.
Yes, record an order. Learned advocates for the parties are present. Learned advocate for the respondent insurance company submits that the compensation amount could not be deposited in time due to certain difficulties. Thus, the time to deposit compensation amount stands extended till 27/7/2026. This is item 29.
29, ma'am.
এটা শুধু 20
My lord, in 30 also I was making the similar prayer. Lordship will kindly extend the time to deposit the check. My lord.
Learned advocate for the appellant insurance company is present. Learned advocate submits that the compensation amount could not be deposited in time due to certain difficulties. Stop. Thus, the time to deposit the compensation amount stands extended till 27/7/2026.
Obliged, your lordship. One, my lord, I am for the appellant. Mr. Sanjay Pal is appearing for the respondents.
So matter was heard earlier.
No, my lord.
Anyway, not today then.
It will retain its same position, my lord.
Yes.
In the list. My lord, in 32, my lord, I was saying, Lord, let the time be extended to deposit the check.
Acha, item 32, learned, Mr. Singh, learned advocate for the respondent. Mr. Singh, learned advocate for respondent insurance company submits that the compensation amount which was awarded could not be deposited within the time fixed due to certain difficulties. Stop. Thus, the time to deposit the compensation amount stands extended till 28/7/2026.
Obliged to my lord, my lord. Obliged.
33, I am appearing, my lord.
To cost title. আচ্ছা
Yes. ওনারের হয়ে পেপারবুক দিয়ে দাও আমাকে দিয়েছো দিয়ে দাও না
Yes, learned advocates for the parties are present. The matter is put up for necessary rectification in the cost title of the order dated 9/7/2026. In order dated 9/7/2026, instead of FMAT MV 832 of 2023, it shall be FMA হবে তো FMA
32 of 2020.
FMA 832 of 2023.
My lord.
Yes.
Apart from that, I am submitting the paper book. Kindly record it, my lord.
The trial court records have come.
Yes, my lord. Perhaps, and I have also.
Okay, the paper books filed by the learned advocate for the respondents' claimants be kept with the record. Liberty to mention.
I have served the copies, my lord. Kindly record it.
It is not necessary.
Deeply obliged, sir. আপনি একটু wait করবেন কপিটা
I'm for the petition.
34. Yes. You are for the petitioner.
I for the opposite party respondents on in the application.
Yes, what is the correction to be made?
Correction, my lord, kindly have a look at page 8 of the my lord's order.
Yes.
Page 8, my lord.
Yes.
Was given to the petitioner judgment data. However, with regard to the direction in order to get such and such, granting liberty to the applicant opposite party judgment data to make an application. But their liberty was granted to the judgment data.
Yes.
While my lord, the next page, my lord, the payment in case of payment of cost, my lord.
Yes, yes, that I have imposed upon you because you are enjoying a decree. So that is no, I was aware about that. Okay.
This is the confusion. That's why.
Anyway, I have because how the judgment debtor is going to pay. Okay. She has some difficulties.
Okay.
So I'm not passing any order. Acha, record an order. As this matter is already disposed, let the matter go out of the list. So take necessary steps.
And for the appellant, in this case, paper book is ready, LCR has already come and submitted, served on the opposite party. It was initially decided on 7th May 25 for hearing, but that day court could not read. So
Yes, record an order. You are for the appellant. Learned advocate for the appellant is present. As this matter was fixed earlier, let this matter appear on 3/8, 3 tarikh.
No, may not give some time because I am to give another notice to them because they are not coming. So 12th August like this.
দেখুন কবে আছে 11 তারিখে 12 তারিখ 11 তারিখ তো ফাঁকা থাকবে 11 12 তারিখ ওকে 12 no 12 yes 12/8/2026 at 2 p.m.
Much obliged.
Necessary service be caused upon the opposite respondents in the meantime. So service through the department is affected upon the respondents. That is to be ascertained also.
And that has been affected. That has been affected
Anyway,
because
you intimate
I have submitted and I submitted the postal receipt and track report also to them. That I have done that.
Okay. 12/8.
Only I give notice to them. That is it.
12/8/2026 at 2 p.m.
Hello, right. Clear, my lord, on the item number 28, there was the affidavit.
Okay, I'll take it up on the next day, tomorrow. Yes.
36.
Item 36, yes.
Lordship, is the injury case, Lordship, the one lady has been suffering injury and 30% disability. Lordship, on the issue of quantum, Lordship, kindly fix any early date if subject to Lordship case died. Cause list.
The 163A or 166? Yes, learned advocates for the parties are present.
Short matter, Mr. MP,
As the matter is ready for hearing, let this matter appear on 4/8/2026. এই 4 তারিখে দেখুন তো টাইমিংসটা একটু ওকে 6/8/2026 at
10:30, Lordship.
12 p.m.
লিখে দিয়েছো?
My lord, it was fixed earlier, my lord.
On
Two
14th,
times.
on 14th, it was fixed, my lord, could not be done.
Yeah. Learned advocates for the parties are present. The matter was heard earlier.
No, my lord.
No, my lord.
No, probably I have heard one matter.
One matter that is under the hearing 119. running.
Learned advocates for the parties are present. As this matter was fixed earlier, let this matter 24 তারিখে দেখুন তো 24 হ্যাঁ 24 তারিখ তো ওই 10:30টায়
24 will be difficult for me. I have another matter in the. No, 23 दिन.
Saturday.
কালকে কেন 23 হ্যাঁ 24 second half
24
after 2.
My lord, kindly.
31 তারিখ দেখুন তো 10:30 31 তারিখ তো আছে কোনো ফিক্সড হয়নি না ফিক্স আছে কিছু
একত্রিশ তারিখে
এই ক্লেম কেস তো একটা ফিক্স আছে
minutes, my lord.
আচ্ছা ঠিক আছে 31 তারিখেই থাক আর কি 10:30 31 তারিখে? হ্যাঁ থাক, ওই সময় থাক, 11টার সময় যদি টাইম পারমিট করে, তারপর নয় দেওয়া যাবে আর কি। না, ওই দিনই ফিক্স করে দেওয়া হবে যদি টাইম না থাকে আর কি। Learned advocates for the parties are present as this matter earlier. Let it appear on 31/7/2026
Grateful, my lord.
at 11 p.m. 11 a.m.
Grateful, my lord.
My lord, one thing I want to say, my lord, item number 14, which order was passed, my lord, in the cause list, it has been incorrectly spelled as Maya Boshak, but the record will show that it is Maya Basu.
Anyway, whatever is it there in the record, that has to be followed.
My lord, and the order has been accrued interest, it may be, the refund may be done.
No, whatever is there in the record, that has to be followed.
My lord, I have deposited in 2010 to my lord in 5 lakhs rupees. So, for with accrued interest, the whole amount may be.
Probably I have recorded that.
Second item 14 ta. My lord, I'm extremely.
Anyway, I'll take it up. At 2 p.m. I shall take it up.
My lord.
On the earlier occasion, the matter was heard. The only point is pay and recover. On the point of, my lord, the violation of the terms and condition regarding route permit. This is the only point. My lord, earlier occasion it was fixed and matter was heard. This is the order passed by your lordship.
This matter?
This one. A order to give in to just to be.
Oh. 5th July.
Only point is pay and recover.
Yes, record and order. Learned advocates for the parties are present as this matter was fixed earlier.
তারিখে তো 7-8টা দেওয়া আছে। 1 তারিখ।
Let this matter appear on. আচ্ছা 30 তারিখে দেখুন তো, 30 তারিখে দেখুন কখন। আচ্ছা 3/8/2026
at 2 p.m.
at 12 p.m. No, at 12:30 p.m. No, 12:30 will not reach court.
আরো 10টা আসতে পারবো না, আমি এখানে 9টায় এসে আছি।
Well, in this matter, I am appearing for the respondent's claimants. Well, your lordship heard this matter earlier, and thereafter your lordship fixed the matter at least 4 times. But
Yes.
not been taken. Can you fix it up? It was
At any day at 4 p.m.
No, my lord, for 10:30.
How much time will it require?
10:30 or 10 to 15 minutes are required.
So 4 p.m. is sufficient.
My lord, your lordship kindly make it 10:30 or 2 p.m. any day in the.
No. Question is how long will you have argued the matter? Only thing is both parties will No. You will conclude and file written notes. How much time will it take?
Fine. But that is not the problem. If my lord any resolution is passed, then my lord.
No, usually resolutions are taken on Friday. Now the present trend. Most of the cases it is taken on Friday. Usually resolutions are not taken. Anyway.
Kindly fix the matter coming Thursday.
Acha, learned advocates for the parties are present as this matter was heard earlier. Let this matter appear on 3/8/2026 at 3 p.m.
Lordship 58 and 59, both the matter I am appearing on behalf of the respondent, and the last 2 occasion the petitioner is not coming, your lordship. This is the application for substitution, both the application for substitution.
Let me see the last order. No, you see, last occasion 17/6, there was a direction to serve copy of can 2 and can 3 upon you.
Yes, Lordship.
So
they
that
have
is done.
served. That they have served.
Okay, now today they are not present. Anyway,
Last two occasions they did
I
not
am find only one thing, 17/6. Yes, record an order. Learned advocate for the respondent is present. None appears for the appellants, petitioners. The matter stands adjourned till 4/8/2026. Learned advocate for the respondent is requested to intimate the other side by notice. So please intimate the other side.
Lordship. Great.
Not today. Yes, not today.
Poor Lord, yes. I am appearing for the appellant, Tiknam Lord.
Yes, can 1 is for?
Can this, can 2 for, that is, application under order 41, rule 27.
And can 1?
Can 1, that was stay application.
So the matter is ready for hearing.
Matter has been heard at length. The appeal was heard. Subsequently, we made the application under order 41, rule 27.
So it is to be heard along with the appeal.
Yes,
But
Lord.
this is settled law. Well, actually, when the appeal was fixed for hearing, at that point of time, they came forward with an application order for 2027. My lord.
Leading me.
Yes, yes, I have heard this matter.
Yes. My lord,
Regarding that compromise degree.
Yes, yes. My deeply.
Yes.
My lord, kindly fix a firm date of hearing of the appeal itself, along with the application.
Yes. Learned advocates for the parties are present. As this matter was heard earlier, let this matter appear on 3/8. 3 তারিখে হচ্ছে না দুটোর সময়? আচ্ছা 4 তারিখে দেখুন 4/5-এ। পাঁচ তারিখে 5/8/2026 at 3 p.m. 5th of August.
5th of August, 3 p.m.
Yes.
ঠিক আছে।
I am thinking for not today, my lord. On behalf of Learned Advocate Suprabhat Bhattacharya.
Okay, not today.
I'm
paying for not today, my lord.
My lord,
Yes.
it's only a substitution application, my lord. They have been served, my lord.
What, this can 3?
2, 3, and 4, my lord.
No, can 1 and 1, 2 and 3.
1 is, my lord, for stay.
Yes, 2.
2 is for one set of defendants who have died and their legal heirs are on record, merely an application.
And 3.
And 3 is there for, my lord, another person.
Anyway, I'm just keeping it on some other day. The interim order is continuing. No, you have prayed for stay.
I have prayed for it. It has not been heard. In the meantime, they have died. It's basically a change brief, my lord.
Okay. Learned advocates for the parties are present. On the prayer of learned advocate for the respondent, the
Appellant.
Appellant, the matter stands adjourned for the day.
Adjourned for
The let the matter stand adjourned till 28/7/2026.
Not today only for.
No, I'll keep it on. I'll take it up on 28/7.
Acha.
Under 28/7.
My lord, if it can be 27, my lord. 28, my lord, I am not there. It's Monday.
Because you see, I take applications on Wednesday.
My lord, 30 or not on Thursday.
আচ্ছা দেখুন তো ওটা কি আচ্ছা ওকে 30th July 2026
নামটা দেবেন হ্যাঁ দিয়ে দিচ্ছি
It's not today.
69. Respondent, my lord.
His applications,
Condonation of delay has not served upon
He
me.
is served upon all, but somehow my learned friend did not get from his client.
can 1, 2, and 3, how
One
can
and two are allowed.
1 and 2 is for,
One is for continuation of delay.
and 2?
2 is for stay application. And 3 is for substitution.
So substitution application
Allowed.
is to be allowed.
Allowed by your lordship.
Okay,
And
one,
earlier.
so 1 has to be taken up.
The section 5 application is executed.
That should be
So-
served, my lord. Notice of application has not been served upon.
Yes, he may not be.
Anyway, let it be not today.
I will give him a copy.
Let him serve, my lord.
And another thing is that
My lord, I think file an opportunity for opposition, my lord. It is a long delay, my lord.
long delay.
Acha,
Long-
learned advocates for the parties are present. The application for condonation of delay being Can 1 of 2023. Can 1 of 2022
22. 23, man.
or 23 is taken up for consideration. Hard learned advocates. Stop. As this application is to be decided on affidavits, the respondents are granted opportunity to file affidavit in opposition on or before 29/7/2026.
27, my lord, is more. Much
1 week's time,
My lord, 2 weeks time, my lord.
5/8/2026. Reply, if any, by 10th August 2026. Let this matter appear on 11/8/2026.
I'm good. ये बात बोल तो ये ऐसे होता है।
না, ডিরেকশন হলো তো টু ফাইল এফিডেভিটস।
I'm good.
I'm for the appellant petitioner, my lord. My application for stay, initially stay was granted by the order 41 court. And
So the appeal is admitted
admitted
and stay was granted. So the paper books are to be made ready,
paper books.
are to be made ready, and the appeal is to be heard out.
No, my lord, the stay application is pending, my lord.
For that
This
stay
is, my lord, for today is fixed for determination of the occupation
No,
charges.
question is, you have filed any petition?
yes.
So let me see that.
Proceedings are complete. They have used an opposition. I have also filed a reply to them.
Applications.
Here one, I can one.
ইয়েটা দিন, অ্যাপ্লিকেশনটা দিন, ইয়েটা। এটা কোথায়? এটা তো শুধু ডকুমেন্টস। পিটিশনটা কোথায়? না, এটা কি করে হবে? কেন? এটা তো সব এটা কোথায় গেল? ও আচ্ছা।
Can one.
আর ইয়েটা কোথায়? ওই
এবার opposition and reply.
you have filed reply also?
Yes. I have also served a copy of the reply. On the last occasion only, I had filed my reply.
So how much occupation charge you are paying now?
Lordship, till the date when the last decree was passed, I'm told, Lordship, we were paying an occupational rent of 3,000 per month.
Okay, let me see the opposition of Mr. Bhattacharya.
My lord, it's, my lord, page 4, para 6. My lord, they are running a liquor business. It's a commercial tenancy. My lord, at the heart, my lord, It is, my lord, near the, my lord, our Royal Calcutta Trust Club, my lord, near Clyde Road.
Lordship, it's a small shop room. Initially, I had started paying rent with only
আগে
300
ক্লিয়ার করো
rupees.
তো তোমরা কবার সাবলেটিং করেছো ইন দ্য মিন টাইম অরিজিনাল টেনেন্ট থেকে
কোনো সাবলেটিং এর কোনো গল্পই নেই।
কতবার করেছো আগে সেটা বলো।
কোনো গল্পই নেই। কাগজ তো
অরিজিনাল টেনেন্ট তো নেই ওখানে। অনেক হাত বদলে গেছে। আমার তো আছে, আমি তো জানি। ওর বাড়ি
রিপ্লেস আমরা করে
এত প্রমাদ গল্প আছে। ফোন করছে তো না, নিচে নেমে গেল।
You are presently paying how much?
3,000 we are paying under the order of the appeal.
Yes?
3,000 under the order of first appellate.
First appellate court.
It was originally 1,500. 300. It was enhanced by the first appellate court to 3,000, 10 times enhancement. I'm complying with that in the best circular, and they are in the affidavit in opposition. They say, but there is a statement, unverified statement, that property would fetch 40,000, 50,000 per month. That is a now 3,000. I'm already, that is enhanced, 10 times enhanced. 300, I'm paying 300,000.
Well, as if Millard, he is saying 209 square feet liquor business, commercial property. Let them vacate, let them vacate, let them vacate.
Takes the point of commercial exploitation or
Let them
property being
vacate
commercial
it.
in nature. Lordship knows the law now. Even in a pending suit, the Commercial Code Act will immediately come into application. His suit will become bad.
Yes, record an order.
Let him vacate. But if he don't take.
Learned advocates for the parties are present. The application for stay is taken up for consideration. Heard learned advocates for the parties. The appellant petitioner has prayed for extension of the ad interim order of stay of execution of the eviction decree passed by the learned trial court. An affidavit in opposition is filed to the said application for stay by the opposite parties. All the opposite parties.
Only one. I'm only one.
Okay, opposite party plaintiff
I have filed a reply.
on the ground that the tenant's appellant is required to pay occupational charge at the market rent. Stop. It is further contended that the said suit property will fetch about rupees 40,000 to rupees 50,000. Stop. Such allegation is disputed by the petitioner appellant in the affidavit in reply, and it is contended that at present the petitioner appellant is paying rupees 3,000 in terms of the order of the first appellate court. Stop.
Which is 10 times.
It is decided in the case of Atmaram by the Honorable, reported in dash by the Honorable Supreme Court, that when an eviction decree is passed, the tenant, in order to occupy the suit property, shall, during pendency of the appeal, pay a fair, reasonable market rent. Stop. Considering the rival contentions of the parties, this court is of the view that it would be just and proper to appoint a special officer to cause an inspection of the suit property and submit a report on the basis of which the market rent, the fair rent of the said property will be determined. Stop. Thus, Dash is appointed as the special officer to cause inspection at the suit property and submit a report. Stop. The learned special officer shall, upon notice to both parties and their learned advocates, visit the suit property, take measurement of the area, take photographs of the building, they record the age of the building and the rents prevailing in the particular area, locality.
Current market
Rents prevailing in that locality of similar types of building. Upon causing necessary inquiry, the learned special officer shall submit a report before this court on 11/8/2026. Let this matter appear on. Yes, the remuneration to be borne equally by both the parties. Yes. The
unfortunate
yes, both parties' interest is involved.
Not my interest, only his interest.
You are occupying, you see, both parties' interest is involved.
I am getting
Let this matter appear on 11/8/2026 for report and further orders.
But I am told, Millard, LCR has already arrived. Let my learned friend prepare paper books, Millard.
That is the direction of
LCR has arrived. Millard, let them prepare paper books.
The paper books be prepared by the appellants in the meantime. You prepare the paper books in the meantime.
Upon scrutiny.
Scrutiny, second appeal. So memo আর দুটো যায়। First.
Evidence লাগাতো।
না, লাগাতো না। Second appeal.
নামগুলো দিয়ে দিস। হ্যাঁ একটা।
হ্যাঁ same. I'm for the respondent number 1, my lord.
Yes.
The application for grant leave to prefer the second.
Yes, I have heard this on the last occasion.
Yes, my lord. আজকে তো নেই দেখছি।
But Mr. Rai has not concluded his argument.
Yes, I have. করবো? My hands are not there today. If your lordship.
Then if you want, I can adjourn it.
No.
Then Milord, I will be beseeching your lordship to fix a date and time so that it
This is an application. It will remain in the list.
Mr. Rai is a busy council.
No,
He will be stuck
my lord.
anywhere.
I am here.
He will be stuck anywhere.
No.
But Wednesday 2 p.m. if your suits your lordship.
Because this is after all an application, okay?
Application.
It's not a
He
ready.
will be stuck, Milord, there. His junior.
I can keep it at 4 p.m. on any day.
Yes.
As your lord. As your lordship.
Yes, learned advocates for the parties are present.
It will take some time. That's why I'm asking for.
That is because I.
1st August, will you come?
Yes,
First, I will be there, Milord.
I'll be there. There is.
I will be there.
Learned advocates for the parties are present.
I'll be there, Milord. I'll be there.
Why?
Except first one on this side, that side, I'll be there.
Learned advocates for the parties are present.
Oh.
By consent of the learned advocates, the matter is fixed on. ও 1st August আসতে পারবে না 7/8/2026 at 4 p.m.
The UG one is on 31st July.
আচ্ছা 7/8 কি ফ্রাইডে হচ্ছে আচ্ছা তাহলে 6/8 কোথাক 6/8 4টের সময় তো বা 5 তারিখে দেখুন 4টের সময় 5/8/2026
It will take some time.
No.
At 3:30 because there will be a chance of 3:30. There may be a chance.
No, করে দেবো।
No, but it will take some time.
4/8/2026 at 3 p.m.
My lord, as you
The interim order granted earlier stands extended for a period of 4 weeks or till further orders, whichever is earlier.
Well, only thing, Milord, your lordship has pleased to record that on consent, Milord, I am not giving consent.
No, date, the fixation of date.
As your lordship.
UG one এর consent দেবে। যত UG one দিয়েছে consent দেবে।
কি এরপরে কি 12টায় 12:15 আছে ঠিক আছে 12:15
উঠে গেল
ills arising out of the
One accident.
accident.
Yes, one accident.
Accident is one accident, but claim cases are two.
Yes. Two separate claim cases, two different awards against which two different appeals.
Yes.
Connected with two different cross objections.
Yes.
These two were going on a motorcycle which met with the accident.
Yes,
Milord.
yes,
Milord, before I start, Milord, I'm not that well ready today, Milord, because this is an issue of contributory negligence. And whether, Milord, this motorcycle dashed against a stationary truck or whether the truck dashed against these motorcyclists, Milord, it has to be, Milord, shown to your Lordship. Milord, it will take some time. Milord, since, Milord, I'm not that well, Milord, ready today, Milord, because of, Milord, the paucity of time.
When can you come ready?
Milord,
First, I have fixed some matters.
Milord,
fixed some matters on first.
Milord, my 4 matters are fixed. I do not know whether if I do not come, then Lordship will, Milord, will again, Milord,
Definitely,
take me to task.
the court has faith on you. I know that you will come unless seriously ill.
Milord, no, Milord, I don't know. I don't take excuses, Milord, but a lot of matters of mine are already fixed on first. Milord, save and accept first, Milord, whenever my London friend is comfortable.
Before first any day.
31 तारीख हाँ 7 तारीख yes learned advocates for the parties are present. Hard learned advocates.
Yes.
Let this matter appear for further hearing on 7/8/2026
Lordship.
at 12:30 p.m. 12 p.m.
Whenever.
This my learned friend took time, your Lordship.
Grateful to your Lordship, Milord.
One humble.
On 7th.
At 7th at 12 p.m. Yes.
One humble prayer, my lord. I shouldn't be mentioning this today. Item 92.
Yes.
It's only on. It's under section 163A, my lord. File is right over here. If
I'll take it up. I think.
she is here. We
No,
both
no.
are here. If it can be disposed of, it will take 2 minutes.
So just now you want to argue?
It's 163A.
अच्छा देखिए recordটা.
Item 92, my lord. Ronnie. Section 163A. My learned friend is appearing.
It is application.
Application. Kindly, my lord, one matter. It will take 2 minutes. My lord will kindly treat it as on days list. 168 days delay.
So the paper books were not filed.
163A. So she has received 2 lakh along with 6% interest. It should be 5 lakh.
This is delay is condoned.
No.
168 days delay.
No.
168 days delay, my lord. My lord will record my objection and my lord will.
येटा देखी ओई मेमो. Yes, record an order.
I'm extremely grateful to my lord.
Learned advocates for the parties are present. By consent of the learned advocates and on the ground of urgency, and considering that the matter is pending from 2017, the matter is taken out of turn.
2010, my lord. MACC 2010.
This appeal.
Appeal is, my lord. I'm sorry.
The appellant in the instant case has filed application for condonation of delay along with the instant appeal. Upon considering the petition for condonation of delay, this court is of the view that sufficient ground is shown. Thus, delay in preferring this appeal is condoned, and the appeal is taken up for consideration. The appellant before this court was a claimant in a case under section 163A of the Motor Vehicles Act 1988 and is aggrieved by the judgment and award dated 3rd day of May 2016 passed by learned Additional District Judge, Second Court Shuri Birbhum in MSC case number 199 of 2010. The case of the claimant petitioner before the learned trial court may be summed up thus. On 19/11/2009 at about 9:30 a.m., while Ganga Harijan, now deceased, was going from Murarai railway gate towards Bhadishwar bus stand by Pakka Road on the way near Syndicate Bank, and at that time the stone-loaded offending vehicle truck bearing number WB-256630 came from Rajgram side and rashly dashed Ganga Harijan stop. As a result of such accident, the victim sustained serious bleeding injury, and thereafter the local people brought her at the Murarai hospital for a treatment. Stop. But the attending doctor declared her dead. Stop. Pursuant to filing of this case, notice was issued upon the opposite parties. Stop. Opposite party vehicle owner did not appear and contest the case. Stop. However, opposite party insurance company contested the case by filing written statement. Stop. Issues were framed and evidence was adduced. Stop. Learned trial judge, upon considering the evidence adduced and upon hearing the learned advocates, was pleased to dispose of the claim case by observing and directing as follows. Hence, it is ordered করে এখান থেকে এই পেজ ফোল্ডেড পেজ করে দিচ্ছি, ঠিক আছে? The claimant as appellants being aggrieved by the quantum of compensation awarded by the learned trial court has come up with the instant application. Our learned advocate for the appellants and learned advocates for the respondent number 1 insurance company.
Bajaj.
Respondent number 1 MS Bajaj Alliance General Insurance Company Limited. Stop. Peruse the judgment and award passed by the learned trial court. It is submitted by the learned trial court that by virtue of the amendments, the appellant claimants are entitled to compensation of rupees 5 lakh. Stop. And the ground of challenge is inadequate compensation awarded by the learned trial court. Learned advocate appearing for the respondent number 1 insurance company disputes the submission of the learned advocate for the appellant and submits that in terms of section 163A of the Motor Vehicles Act 1988, there is no error passed by the learned trial judge. Upon hearing the learned advocates and considering the amendments made out in section 164 of the Motor Vehicles Act, which provides uniform compensation of any case under section 163A where death has occurred as rupees 5 lakh. Stop. As motor vehicle claim legislation is a beneficial legislation, the claimants appellants should be permitted to take the benefit of the amendments incorporated in the said statute. Stop. In the facts and circumstances, this appeal FMAT 69 of 2017 stands disposed. The judgment and award dated 3rd May 2016 passed in MSC case number 199 of 2010 stands modified to the extent that the appellant claimants are entitled, appellant claimant
Yes, single claimant.
Appellant claimant is entitled to compensation of rupees 5 lakh along with interest at the rate of 6% per annum from the date of filing claim case till today. Stop. The respondent number 1 Bajaj Alliance General Insurance Company Limited shall deposit rupees 5 lakh along with interest at the rate of 6% per annum before Registrar General High Court, Calcutta, within 8 weeks from the date of communication of this order. Stop. In the event the compensation awarded by the learned trial court is already deposited, the balance amount be deposited by the insurance company. Stop. The claimant appellant will be entitled to withdraw the compensation upon compliance of necessary formalities. The claimant appellant shall also pay the deficit court fees of the enhanced compensation within 2 weeks.
Wherein my lord has recorded in the event it has been deposited, my lord, they have already received. In the event it is received.
Anyway, so
My lord,
you are protected by
my
that.
lord, I'm extremely grateful, my lord, extremely grateful.
Okay, okay. Let this matter be taken up just. So other side is not here.
On the earlier occasion, I have concluded my argument. Other side is not.
Anyway, so it cannot be taken up today.
Your lordship directed me to file the written notes of argument also, which is ready. Can I file it today now?
Anyway, I am making it not today.
Kindly,
So let this matter appear as to be mentioned.
your lordship kindly fix it in the fixed matter.
And in the presence of both sides, I shall fix it. Let this matter appear as to be mentioned on 28/7/2026.
28/7.
হ্যাঁ আচ্ছা ঠিক আছে তাহলে it will appear as to be mentioned. I'm making it not today, it will appear as to be mentioned.
Item number 6, I am representing the appellant, Sulata Kanji, FMA 188.
So both are railway claim cases.
So railway claim cases, I have concluded my argument.
Anyway, I'm just making it not today.
It will appear in the.
So that it will appear as to be mentioned, and in presence of both sides, date will be fixed. Next week. Yes, what is your matter? Yes, yes, what is your matter? Yes, yes. Yes. Yes.
That is unfortunately is the heading list. The railway claim case. The appellant is mother. The victim is the 19 years old. Gone.
221. Ajay, I'm making it will not be taken up. Let it be not today, let it appear as to be mentioned. It will appear as to be mentioned. Next week, so in the presence of both sides, I shall fix the date.
Present.
Item? Yes. Item 6, give the records.
তুমি এসে গেছে নাকি? Item number 6, your lordship is present.
Yes, item 6, you are to commence today.
I have concluded my argument. I was supposed to file the written notes of argument. So this is ready with me. Judgments I am giving today.
Anyway, whatever he is to give, he will give in his written notes of arguments. You make your submissions. আচ্ছা রেকর্ডটা দিন একটু
নোটস অফ আর্গুমেন্ট আপনাকে আমি কপি দিয়ে দিচ্ছি
এটা দিন আমার হ্যান্ড রিটেন নোটসটা ঠিক আছে Yes, what are your submissions? Yes.
He has lost his skill. He fell down from the running plane and thereby died and claimed compensation of 58 lakhs. Short Melod had 4-5 points that by the reading. One Melod, there is not a single eyewitness. There is not a single eyewitness when the victim died.
Yes.
Number two, Melod, case made out is that wife was traveling with the husband, the victim, whereas not a single document produced that she was traveling with the victim.
Yes.
Third one, Melod, the Caesar list was prepared in the evening.
Yes.
The victim died in the afternoon.
Prepared on in the evening.
Same way evening at 5:35 evening. Whereas as per the claim lodged by the claimant, he died in the afternoon. This not gap itself creates a doubt. And not a single piece of document to justify that the person died by fell down from the plane. And thereby it is not coming under the definition of untoward accident under which the claim is made.
Yes.
Number D, that should be DRL report, inquiry report. The inquiry report is based upon the statement of motorman, statement of the guard, statement of the station master, statement of the RPF Jawan. All have not has confirmed that it was a knockdown case. It is not the fall down case. The passenger has fallen down from the plane. The DRL report has given full finding based on the documentary evidence that no, it was not a case of fall down from the running plane. And that is a part of the paper DRL report. I will explain the statements. Not after not doing all these documents, the criminal has rightly rejected the claim of the claim. Now, not where we have agreed to finally coming on page 52 of the paper. Judgment.
Just a yes, page
52.
52.
His judgment is not judgment from the application. This application has been filed in the second section of the Railway Tribunal Act and 12/124 of the Railway by and the parents of the deceased Sachin Gandhi for compensation on account of death of the victim who was allegedly died in an untoward incident. The history of the case of the applicant is that on 23rd October 21, the deceased along with wife was allegedly traveling from Kumar Diamond Harbour Railway by Diamond Harbour property, where he Diamond Harbour to Butiyari series via Sonarpur. He accidentally fell from a running train between Sonarpur and Kumakulam railway station. He sustained injury and died on the spot. The respondent railway has filed a written statement denying the fact stated in the claim application. The respondent has challenged the inquest report and the serial list. The witness in both these documents are not present at the time of the incident. The following issues were faced. One, whether the incident on account of which the victim is alleged can be termed as an untoward incident as defined under section 12. Whether the victim was a bona fide railway passenger, whether the applicants are the dependents of the deceased and are entitled to get compensation as paid for. What other means, if any, the applicant files election ID card of the Corona country, state certificate of the forest country, medical report, final police report, PM report, railway ticket, visa list, and original railway ticket. Respondents railway has furnished the inquiry report duly accepted by DRN. The respondent. Applicant Sureja Gandhi, wife of deceased, filed an affidavit affirming the fact put forward in the claim application. He was also examined and cross-examined as A2. After hearing the argument of both sides and reviewing the evidence available on file 1, I proceed to decide the issue as issue number 182. These issues are taken up together for decision as they are interrelated. Among the documents filed by this applicant, FRAC reveals that PS Subhadra memo that as reported by SM Smart, one unknown male person aged about 45 years was knocked down and lying dead at kilometer Sonarpur and Subhadram outside of that. He was knocked down. UD case number 22 was registered in Sonarpur DRPS. As per the inquest report, the IO learned from the witness that in the morning of the deceased, the deceased accompanied by his wife traveled from Diamond Harbour to Utiyari by plane. And while returning to Diamond Harbour, he and his wife boarded separate compartments from Sonarpur railway station due to overcrowding of the passengers. He fell down from a plane between Sonarpur and the Padma. After falling down from the plane at Diamond Harbour, when the wife of the deceased could not trace her husband, he informed the matter to her relative. Then the relatives tried to find out about the deceased by walking along the railway track. Finally, they found the dead body of the deceased. Afterward, the DRP personnel reached the spot. The dead body was sent for postmortem examination. The PM report opined that the death of the victim was due to the effect of injury, which was anti-mortem in nature. The final police report did not throw any light upon the cause of death of the deceased. The original ticket is seen on record. The DRS report says that it was an accident of being knocked down. During inquiry on duty, a RPF post-mortem states that after receiving the information from section control, he rushed to the spot where he found one dead body lying at the so-and-so number between Sonarpur and his father. Upon local inquiry, he came to know that the said person was knocked down by an unknown train. Till removal of the dead body, no relative attended the spot and identity of the deceased was unknown. The inquiry officer also recorded the statement of Surya Gandhi and Devu Maiti and Susanjit Maiti, who witnessed the inquest report and serial. Surya Gandhi stated that when she reached Diamond Harbour railway station and was looking for her husband, she did not find him. She overheard that some passengers were talking that one male person had fallen down from plane between Sonarpur and Isfahan railway station. Then she called her relative, Devumaiti, over the phone and told him to go to TRPS North. Then she proceeded to go home. After some time, Devumaiti called her over phone mobile phone that her husband was at Sonarpur TRPS in injured condition. After that, he along with her relative went to Sonarpur TRPS and learned from Devumaiti that her husband had fallen down from the plane between Sonarpur and Isfahan. Devumaiti stated that on 23rd March 21 at about 15, it might be wrong, 50 hours, at evening hours, 50 hours, Surya Gandhi claimant informed him over the mobile phone that she and Sachin boarded the Diamond Harbour super train in different compartments. And after reaching Diamond Harbour railway station, she could not trace Sachin Gandhi. After hearing this, Devumati went to TRPS Nagpur, where photos of the victim were shown to him, and he identified the victim as his brother-in-law Sachin. Prasenjit Gandhi stated that when he came to know from his wife that his brother Sachin Gandhi has got injured, he then called Sachin Gandhi over his wife. One lady of the Sunarpur DRPS received the call and informed him that Sachin Gandhi was at Sunarpur DRPS in injured condition. He asked him to attend Sunarpur DRPS. He went to show his relative. Devu might be already present there. He learned from Devu Mighty that Sachin Gandhi has fallen down from a plane and has died. Dead body has already been sent to Sadar for postmortem. It is brought out from the above statement of Gupta Gandhi, claiming Devu Mighty and Prasenjit Mighty that they were not present at the time of the occurrence of the incident. They did not witness the alleged incident at all. But as per the inquest report, relatives of the deceased walking along a railway track and they found the dead body at the deceased. Thereafter, DRP personnel and Sunarpur DRPS came to the place of offence. In their opinion, the deceased fell down from their train. Based on their person, the IO of DRPS also opined that cause of death of the deceased was fell down from train. Devu Maiti and Sarath Motor signed on the inquest report as witness. On the contrary, when RPF official recorded the statement of Devu Maiti, he stated that he was informed by Gurda Gandhi over phone that deceased was missing at Ahmedabad railway station. And thereafter, when he went to the North DRPS, they showed the photograph of the victim. And based on the photograph, he identified the victim as deceased. The dead body was already sent to the other for postmortem examination. On his admission, he was not present at the time of offence. From the above, the inquest report and the statement of the inquest witness are seen to be at variance. Above all, the witness Devu Maiti, who has signed on the inquest report, is proved not to have been present at the time of the alleged incident by his own admission to RPF. Hence, it is obvious that Devu Maiti's signature on the inquest report was obtained later. Hence, the inquest report of the GRPS cannot be given copy to an eye of law. Moreover, the final police report did not show any light on the cause of death of the deceased. As per the ticket is concerned, the applicant has produced a Caesar list featuring railway ticket number so dated 23rd October 21, which was witnessed by Devu Maiti and Prasenjit Maiti. Whereas their own admission to RPF.
No, any railway ticket was seized from the victim's possession.
It was there.
No, whether the railway ticket was seized from the victim's possession.
It was produced at the time of inquisition.
Okay, railway ticket.
Not on the dead body.
No, in the Caesar list. Caesar list is there.
In the evening.
Where do we get Caesar list is prepared in the evening?
At the time of this event,
Yes.
conclude.
No, yes, sir. That is why asking that as per the police version, railway ticket is found is recovered from the possession of the victim.
It was taken for postmortem. Caesar list prepared.
From where did the yes.
Can you come to the
Page 65 is the ticket.
Is the certified copy of ticket. Original is also on record. 64 is Caesar list.
64
of paper.
That
is your. This Caesar list also was delayed by them.
64 Caesar list. Okay. Article seized railway ticket.
Yes.
Okay. Place and time of seizure.
This is at 5:35 p.m.
No. Place and time. Place and date and time of seizure on 23/10/2021. Place of seized at kilometer post 18.5 towards Subhasgram. RS. This is the Caesar list. What it says. Yes. 70. Yes. 5:35 hours. Yes. This is the date and time of seizure. Yes. Next.
I was reading about letter 7.
Yes.
We got out from the statement of Kucha that they were not present at the time of appearance of the incident. They did not witness the alleged incident at all. But as per the inquest report, relative of the deceased walking along the railway track, they found that dead body of the deceased. Thereafter, GRP personnel of the SWAT GRP came to the place of occurrence. In their opinion, the deceased fell down from the train based on their version. The IO of GRP also find that the cause of death of the deceased was fall from train. Devumachi and Sharat Mandal signed of the incident report as a witness. On the contrary, when RPF officer recorded the statement of Devumachi, he stated that he was informed by Sulta Sandi over phone that the deceased was missing at Diamond Harbour railway station. And thereafter, when he went to the DRPF, they showed the photograph of the victim, and based on the photograph, he identified the victim as deceased. The dead body was already sent to the other postmortem examination. On his own admission, he was not present at the time of the accident. From the above, the inquest report and the statement of the inquest witness are seen as varying. Above all, the witness that is named who has signed on the inquest report is proved not to have been present at the time of the alleged incident of no admission. Hence, it is obvious that Devumachi's selection of the inquest report was a state letter. Hence, the inquest report of the DRPS cannot be given for the in IS law. Moreover, the final police report did not throw any light on the cause of death of the deceased. As far as ticket is concerned, the applicant has produced a Caesar list preparing their proof which was witnessed by Devumachi and presented Kanji. It was witnessed by Devumachi and the Kanji, whereas by their own admission to RPF, they have not reached a place of occurrence at all. Hence, the question of witnessing the Caesar by them does not arise. Firstly, both of them were not independent witness at all, being direct relative of the deceased. Hence, Caesar of the ticket is not credible at all because the so-called witness were never present at all when the Caesar list was prepared. Therefore, the applicant miserably failed to prove that because of death of the deceased was called from the claim that he was a bona fide passenger. The Honorable High Court of Andhra Pradesh that held in case of so it is clear that the applicant has come to court asserting some fact must prove that the death of the deceased has taken place in untoward accident and that the death occurred while the deceased was traveling in a train carrying passenger as a passenger and heredity. Therefore, having asserted that deceased died in the untoward incident and he is having a valid ticket at the time of death, the initial burden lies upon the applicant to establish the same. The initial burden of the applicant never ceases unless the respondent admits the assertion made by the applicant. Such evidence is lacking in this case. The applicant could not succeed in proving her excluded evidence that the deceased was traveling in a train on the date of the incident and that incident was caused by injury due to fall from the running train. Besides, the journey ticket could not have proved to be belong to the deceased. Considering the factual element coming out of the decision, these issues are answered in favor of the respondent by holding that there was no untoward incident by defining it as a of the delivery. Therefore, issue number 3 and 4.
How many witnesses were examined by the claimants? Only wife.
Wife was the co-passenger person.
Okay. Any witness examined by railway authority?
Inquiry report still there are 6 statements. Statement of six persons. Motorman, guards, RPS 1, they are all part of the DRE report.
That is during the internal investigation.
It is inquiry.
Nobody was
And that is not challenged. Inquiry report has not been challenged by entry.
Inquiry report was exhibited. Where? No. Inquiry report is exhibited by the. It has to be exhibited by deposition, unless there is a consent.
Exhibit R1, page
53.
Clause 4. The respondent railway has furnished the inquiry report to be accepted by DRM. Mark exhibit R1. Clause 4, clause 14.
Okay.
It was not challenged by the claimant that inquiry report is biased or it is something.
And yes,
Now,
but So comparison of both police report and the inquiry report, whichever inspires confidence in the minds of the court will accept that. Inquiry report is the railway authorities, okay? Police report is the police is not any of the parties. It is a third party. So whichever report convinces the court, inspires confidence in the minds of court will accept that.
No, not based on evidence.
Yes, nobody, these type of cases, nobody will be the eyewitness. You hardly will find any eyewitness, okay? So, either on the report of the railway authority and the police authority, the court has to base its decision, whichever inspires my confidence.
Not this entire case depends on evidence.
What evidence will this wife give? What evidence will this wife give? The wife will say that, yes, I was traveling with him. Very well, whether if from the how she will keep the ticket all along till evidence. What does a yes 2%? No. Usually the husband purchases the tickets and keeps with him. No, definitely not. You see, 2 tickets are not necessary. Earlier, for 4%, 3%, 3 tickets were issued, but at present, the system is such for 2 or 3% also 1 ticket is sufficient, and it is reflected. And usually it is the husband who purchases the tickets and keeps with him.
Suppose that ticket is credible, but it is one ticket, not
How? No. 1 ticket means what? Now you see, presently this type of tickets, is it mentioned only 1 ticket in the where?
Because at the time of returning,
No. Let us see the ticket.
One adult.
No. Let us see this ticket page.
You not see.
Because you see, these are singled in 1 ticket. It is mentioned. It should be mentioned.
If your lordship is adult one, page 65, page 66. Page 63 in my paper. I think page 65, 65, what is the copy of it?
65.
65.
That is 30, total 30. No. Question is, what is the, you see, Ghutiari Sharif to Diamond Harbour, okay? What is the price of the, actually that is not clear.
Is it return ticket?
No, the return ticket, yes.
Computerized ticket at the time of commence.
3%, 1 ticket, at the time of 3%, 4%. Now that earlier,
Yes, separate pieces.
but now it is gone. It is out.
Yes, one.
Can you come to claim? Can you come to claim? He has said he was traveling together.
No, let us see the value of the ticket. Okay.
50 rupees.
Both way.
Both way. Because at the time of returning, her victim's wife was in the ladies' compartment.
No, maybe, but what is the price? Is it mentioned that to valid for 1 return journey?
It mentioned one return journey.
So where do you get? Because you see, even if it is 3 persons also, it will be in 1 ticket. Now, from which column you say that there is 2 tickets?
2 tickets at the time of returning. That ticket was separate, was with her victim's wife, because at the time of traveling from Sonarpur, the victim's wife boarded in ladies' compartment. So her ticket was 50.
No. If it is 1 ticket itself, then there is no scope to give to the wife. It will be either with the wife or with the husband.
This ticket was with the husband.
Okay, but is it because you see in 1 ticket itself, if there are 2 persons, then 2 charges will be there.
Charges, for that 2 charges will be there.
So this 1 ticket is sufficient.
1 ticket is sufficient.
So it is not necessary that there will be 2 tickets.
He has made a claim that he was traveling with the husband. He has to prove that he was traveling.
So let us see from whether the evidence is sufficient for proof.
Yes.
Because you see, this is not a reserved compartment, okay? It is a general compartment.
The railway is not going to deny the compensation given to the person. But it has to be proved by documentary evidence.
And you see, this railway claim case is not required to be proved beyond reasonable doubt. Mere preponderance of probability. So what else she will get?
kindly see the reading, kindly see the claim petition. Kindly come to page. Kindly come to page 4. Begin from page 2. Then come to page number, then come to page 4.
Yes.
Come on to follow.
Yes. Yes.
Was a passenger of the victim was traveling with the return journey ticket from Diamond Harbour to PRT Delhi, was not to get ticket number 22, having time of between 7.15. This case of was traveling, doesn't say he was traveling with the victim. Victim was traveling alone. It doesn't say he was traveling with the wife.
No, it is mentioned in the page 5. With the detail.
Okay, let's come to page 5.
Yes.
Page 4, the victim was traveling with a return journey ticket.
Yes. It doesn't say with the wife.
It is not necessary.
No, I'm showing you the
So many things are not required to be said.
I'm showing you
These are particulars, okay? All those things can be stated in evidence, in affidavits.
Page 5.
Okay, I'm coming to page 5.
Yes.
Page 5 it is first paragraph.
Then note, and you see clause.
This is the claim application, your lordship. There are some specific columns.
Anyway, page 5, what is there?
Please, all the clauses, sir.
Yes. What is there in page 5?
I'm coming to clause 5. Can you come to clause 2?
Clause 2, yes.
No, clause 1, sub-clause I.
Clause.
What was the serial name prepared? Yes. If yes, time of preparation, the article will candidate serial question. If yes, if the serial was prepared, then please, if there time of preparation, the article cease and the name of the person who has signed in the memo of serial list. Name. This will be filled up. Next. Now, can you see? 2, paragraph 2. Do you know the detail of journey that the victim was undertaking, namely the station from? If yes, give the detail of the station of origin and the destination of the victim at the time of the accident was traveling from Sonarpur to Diamond Harbour station.
Sonarpur to Diamond Harbour, and the accident took place between Sonarpur and Subhasgram.
Yes.
That means on the following station of Sonarpur.
Yes. Do you know the name of the train number? In which train to travel or attend to travel? Yes. Anything answer? Nothing.
No. Next is the answer.
If yes, give the detailed details. Victim was traveling in the down Seattle Harbour. Train number is not given.
Train number, it is not possible. Train name I have mentioned.
So if you give a comment slide,
Okay.
I didn't disturb you.
Yes.
Page 5. Closely. Was there no co-passenger with the victim? Yes. Yes. If yes, the name of the co-passenger, nature of the relationship, and friendship. Nothing. If she was traveling, she should say that, yes, I was.
No, the victim was traveling with her wife, Sulata Kanji. Yes, paragraph.
The victim was traveling with her wife, Sulata Kanji. So due to overcrowding in the down Diamond Harbour local during the time of boarding of this station, the victim's wife could not board in the same compartment with the husband. Instead, she boarded in the adjacent compartment of the same train. Was there any eyewitness in the victim's travel? No. No, there is no eyewitness. Then we kindly come to the clause Roman 3 in the bottom. This is the narrative we are giving. The accident took place on 23rd October 2021 afternoon. I notice afternoon. Incident took place in afternoon. The victim, who was a resident of Calcutta, on 23rd October early morning came to Diamond Harbour station from Mumbai to the country. The nearest and convenient railway station from the house, and after proceeding a return journey ticket from Diamond Harbour to the PRE station. Both of them, where is the two tickets? Both of them, had they been both of them, there must be two tickets, at least should be period there. Both of them boarded a local train. No, while returning, they were crowded in minutes for while doing, there was no crowd in the train boarded together. Boarded a local train from the Diamond Harbour.
So these occurred at the time of return journey.
He was on his way to PRE station to his relative's house and also for personal work purpose. On their way, they alight at Smart Junction station to catch a train for PRE station. As there is no direct train station available on the particular route from Denver. After completion of his work and brief stay at the relative's house, they again came to Smart station and boarded. They again came down to Sonarpur Junction station and boarded a down Diamond Harbour local train from that station, reached his house in Namdar. As the train was very crowded, the victim and his wife could not board in the same compartment. The victim's wife boarded at the same compartment, and the victim only managed to stood near the gate of the compartment where continuous jostling was going on. And when the train reached at the came going to between Sonarpur and the Swazgan station, due to the pressure of the inside the passenger, he lost his balance and fell down. How could it be said by the claimant that how he fell down? Some deposit or he lost his balance. And how he could be said by the claimant because she was not there in the claim. It's all presumption that at the place of occurrence. The victim
Now the question is, was any inquiry made and evidence adduced that the time of the accident, no Diamond Harbour local passes from that area?
Yes.
Any inquiry that at that time, relevant time, there is no Diamond Harbour local, some other locals are passed. It is a specific case that she and her husband boarded in Diamond Harbour local. And at that point of time, if no Diamond Harbour local passes, then case goes.
Yes. But it is not possible to foresee 4 hours.
No. Suppose time is 3:30 or 4:30 approximately. At that point of time, she has boarded or with her husband, Diamond Harbour local from so and so junction. If in the schedule nearby 1 hour or 1.5 hours, there is no mention Diamond Harbour local, some other locals are there, then the case goes. Anyway, if the authority has inquired and adduced this evidence, then the case will go. No, that is the inquiry. If the authority can show that from this time to this time, approximate time of this incident. No, from inquiry. It's an incident took place long time ago. From inquiry and in evidence, was this adduced? Let us see that.
Part of the paperwork. The victim's wife, it is her statement that he was pushed by the crowd and he fell down. It is the presumption of the wife who was in the adjacent compartment came to know from other passengers where she got other passengers in the afternoon and she is getting this incident evening 5:45. When the plane reached Diamond Harbour station, he alighted from the plane and waited for the husband and could not find him in the station after a lot of searching. Then he informed his family member about such incident and also informed his brother who was resident at Sonarpur. In meantime, on the being officially informed by the booking supervisor of Sonarpur railway station through a memo which was treated as an FIR, investigation officer of Sonarpur PRPF reached the spot at 5:17, 15 or 35 hours and prepared a inquest report in the presence of available witness. Photography of the FIR and memo of the inquest report are annexed. Was recovered from the body of the which was the photocopy of the which is marked here and is marked with letter B. Subsequently, the dead body was sent for postmortem and photocopy of the postmortem report is the next year. this is not the statement of the claimant. It's not only hearsay statement. She heard from the other passenger that he was filled down by the crowd, and not this is the incident. Clear it out. She has not given a positive statement that he was falling down from the train and he died. And this is not a claim of the petitioner. And in clause 3, can you see? Admission. Clause 3A. Is there any eyewitness to the incident? The applicant did not have any personal knowledge whether there was any eyewitness or not. So admission, there is no eyewitness. Nobody has seen him, whether he was lying there, or he was knocked down by a train, or he fallen down from train, not clear. Then kindly come to the bottom, FIR requested code, other code, then kindly come to the last page of the main road, page 8. Where in the application, applicant now pays for amount of 8 lakhs. On what basis? What is the basis of claim?
No, 8 lakh is provided under the schedule, whatever is there in the schedule. That no. Question is the court cannot reduce it or enhance it. Whatever is there, the court is bound to follow.
If it is an untoward incident,
Unless it is an untoward incident, the court cannot grant any compensation. The court has to dismiss the compensation. But with regard to the quantum, that is fixed, that there is no question of any variation.
case of untoward incident.
Yes, definitely.
But the court has finding that there is no untoward incident.
Very well. So the court has rightly rejected. If there is no findings, if the court does not believe to be an untoward incident, it has to be rejected.
That was our kindly court allowed to place by statement.
Yes.
Page 9.
Yes.
Then the purported claim application or further claim of the victim is confusing, speculative, and frivolous, and not at all maintainable in the law as well as in the fact, as it is not a fallen down case and does not fall under section 223 of the Railway Act. Suppressing all the material facts and concealing the truth and making a total departure from the real truth and distorting the fact, the applicant has filed the instant claim with the sole object takes illegal gain from the public statement. The locus of the applicant for filing the claim is disputed as he has not submitted the legal aid certificate of herself and other dependent from the competent authority. Claim application is not maintainable due to defect in the cause of action of the instant case as it has been wrongly stated in the claim application since it was not fallen down case as mentioned in the claim application. The applicant has usually failed to prove that the instant case was an untoward incident case under section 123 C2 of the Railway Act. That in respect of R1, paragraph 150 of the claim, the respondent has no knowledge regarding the same, and the applicant has to prove the same by producing valid documents and description. It is admitted by the applicant in a claim application that he has not seen alleged incident as he was traveling and in the separate compartment, there is ladies compartment, he is playing on the gate of alleged incident. The respondent submit that there was no eyewitness of the alleged incident, no direct evidence incident, no proof to prove that it was a fallen down case from running train. The guard or driver of any train carrying passengers did not report regarding any of the untoward incident happened on the same alleged spot. Moreover, the motorman and the guard of train number 22 of 23rd October also stated in their statement attached to the DVR report that they did not notice or no information was received from anybody regarding any of the incident during that their duty period on the incident day. So it was not a fallen down case from running train. The applicant is put to a strict proof that they were an eyewitness of the alleged incident. The applicant must bring an eyewitness before the tribunal to corroborate the safe fact of alleged fall down from the plane by submitting the railway ticket to prove that he was the component on the same date of the alleged incident. The person who has put their signature on the inquest report are the relatives of the victim, as the applicant is sister-in-law of the victim who has stated in his statement and next to the DR report that the applicant informed me about the missing of the victim and subsequently given to TRPS Sonarpur, where he had shown the photographs of the victim. And the TRPS authority told him, and the victim fell down from the running thing and died, and he put his signature on the inquest report. So he was not the eyewitness of the alleged incident, and as such the inquest report is a effective one and cannot be effective as per the law, as the signature was not taken for alleged incident spot. The same there might be another witness, although stated in the statement attached to the DRM report that they put their signature later on and not at the alleged incident of where the inquest was done. So the reader list is also concluded and it was not made according to the law. Therefore, respondent is read by jury both the inquest report and reader list and both the documents were not prepared according to the law. As such, the person of the witness as stated in the inquest report hearsay in nature of the nature and TRPS authority did not ask or interrogate the applicant that is the wife of the victim as he claimed that he was traveling with the victim on train to a separate compartment to reveal the correct and real facts of the incident. The final report, reflects the knockdown of the victim by running state, but in conclusion, no specific case of death of the victim has been mentioned therein. The FIR was lodged as per the remain memo, which clearly speaks regarding knockdown of the victim from the running train and the person of the victim in the hearsay in nature regarding the fact of the alleged falling down of the victim from train. Moreover, the applicant was not submitted any proof that final police report has been accepted by the concerned magistrate as per law to prove the alleged incident as an untoward incident. The entire story has narrated in the case of the fabricated one and only to create compensation illegally from the daily. It is very strangely that no alarm change was done by anybody after the alleged incident. Therefore, it is clear that there was no eyewitness of the alleged incident, and it is not established that victim fell down from the running train. On the respective party, so the respondent strongly denied that there was any such eyewitness of the alleged incident who had seen the alleged falling down of the victim from the running train. Therefore, the entire fact as stated by the applicant regarding alleged falling down of the victim from the said alleged incident for is a confirmed story. As such, the applicant must bring an eyewitness and or any other police document before the learned tribunal to prove the incident as untrue incident. The respondent denies and proved the statement as contained therein and states that applicant has not stated any concrete proof regarding cause of happening of the alleged incident, and she has to bring the valid evidence before the tribunal who has seen the victim boarded any train and fell down from the any running train as I says. No alarm chain pulling was done anyway on the same or on the same day. So presence of the eyewitness is strongly denied and not challenged by the respondent. The respondent submits that all the conditions may be placed of the question by the applicant and moreover, the analyst is totally silent regarding the actual and specific cause of the individual. The respondent submits that alleged incident was not fallen down from a running train and there was no eyewitness of the alleged incident. Failure to submit their original DRM report also, along with its accept of the incident, is witness statement and also claim to exhibit the same as R1. As the DRM report, the conclusion, it is mentioned that as per available record and evidence such as railway memo of the Subhash RS, station diary of the Subhash RS, statement of visiting officer of the RPS North, etc. It is proof that it was an accident of knockdown by a running train resulting death on the spot, as there is no specific proof that victim accident is fallen down or any running train as alleged claimed by the application. Therefore, the respondent submit the applicant has stated in shortest story in the claim application only to place the money from the government statement. The cause of action of this case is also disputed that there is no concrete cogent proof that the alleged incident was fallen down from the running train. That the applicant has proved that the cause of death of the victim was not due to any cause and mentioned in A of the settlement report. The respondent therefore strongly submit that earlier the incident was not fallen down and does not come under the provision of 152 of the Railway Act. There is no proof submitted by the applicant that the said final question has been accepted by the concerned magistrate as per the law. There is honest state that the state must by noticing the event as a business and certified to the particular is honest state they have to give value to claim again. This is our again statement and not we have connected we have the connect by state has considered all the evidences reports before passing this out. So this evidence was asked by the judge is for a good reason and based on the proper appreciation of the pleadings, evidences, and federal principle of law. I am not appealing the order and meaning. It doesn't require any independent by the court because it is not a case of unfolding hearing. Now, Lord, I place for the air report. If you place the air report, Lord, the excess there, the statements are.
Okay, this decision is delayed by you. No, this decision.
Yes, Your Lordship. I have also submitted the written arguments along with some.
No, this is these three decisions submitted by you.
That I have submitted.
Okay. Yes, what report you want to delay?
So I don't that I
Yes, you read. Hey, এটা দিন তো একটু।
May I have a copy of the delivered
No. You should go through this judgment. You submit. Very well, you go through.
and give note something.
Then you better conclude and submit your written notes after going through that judgment. No, you conclude today. I shall fix another date because your learned friend has submitted written notes. You also submit written notes on the next day. You just conclude from. Better instead of arguing, you submit your written notes on the next day. Yes, you better give your learned friend a copy so that both of you can. On the next day, yes. Yes. With regard to report, what do you want to submit? Yes. Yes.
Start from 50 and you compare of 50.
Yes.
50 dated 9 June 22.
Yes.
In reference to the above, it is form. The RCT case file was received by Swento on 22nd February 2022. The same was endorsed to SI Ashutosh Kumar Gautam of RPF. In court of inquiry, he collected relevant documents, police record, as well as examined the witness and concerned persons. On the basis of evidence collected so far, he came on the conclusion that the deceased person, namely Sachin Gandhi, was found dead and his body was lying outside the track of kilometer in station between Sonarpur and Swarnam. There was no evidence found regarding his death happened to be fallen down from the tree. The ticket which was allegedly found from the person of the deceased was issued by Diamond Harbour Railway Station at 17:15 hours. Takes Diamond Harbour to Kerry and back, but the incident occurred at about 14:20 hours as per the SS Valley by the side of the down track. On the basis of statement of on duty, SRD statement of on duty officer ASI Anu Senapati, who attended the PU, and statement of both senior witnesses, namely Devu Maiti and Pratik Maiti, complained of it is fact that the deceased person, namely Satish Gandhi, was found dead, and dead body was lying outside the track of the in between Suvarnam and not railway station. In course of inquiry, the cause of death of Sachin Gandhi could not be ascertained from any cause due to lack of evidence, and hence there is no any evidence from any cause, and no one is eyewitness of the incident. that he has fallen down from the train. Again, state also and part of the railway also not found during inquiry. As to the memo of BS SETR and station diary of so-and-so railway station of so as per the statement of visiting officer, Senapati of the RPF, it is clear that it was the incident of knockdown of the knockdown. Therefore, no any lapses on the part of railway administration. This railway is not liable to pay any compensation to the prisoner in the matter of untold incident. I am understand the and agree with the inquiry. This is the inquiry of this year. Now the panic is an excess. Panic comes to page 90. This is about the report of inquiry office. Not to EU office. Here, my lord, can you see start from page 19, but the relevant portion I will page 20, and you can page 20. This is not given by us. Right, RPO.
Yes.
And the result of inquiry and opinion. On the basis of above inquiry, evidence collected so far, and the statement of on-duty PSSCR, namely Ravindra Mongol, the statement of on-duty officer ASI Alochana, who attended the PU, and statement of both senior witnesses, namely Ziku Maiti and Sunjit Maiti, from variant of this case. It is fact that the chief person, namely Sachin Kanji, was found dead, and dead body was lying outside the train of the the cause of death could not be ascertained from any corner, and due to lack of consolidated evidence and eyewitness during inquiry, and there is no evidence from any corner that no one is eyewitness of the incident that is current on the train. As per the memo of so and the secondary so and as per the statement of the team officer, it is clear it was the incident of knockdown and not the current. Then we will find come to page 22. It is guard, the statement of the guard, or Ram Kumar Verma. 23rd October. On page 24.
Yes, yes.
Ram Kumar Verma, the guard Sialda. On being asked, Ram Kumar Verma, Sialda is voluntarily stating without any fear, any inducement or any pressure that I could be out of issues from manager Sialda. I was booked as guard of train number so and so, which left Sialda railway station at 14:10 hours and arrived Diamond Harbour at 15:47 hours during my duty period. No issue knockdown or run over incident happened at kilometer 22.
So he is telling no knockdown or no run over.
Yes, no knockdown.
This is the guard of that particular train.
Yes. No knockdown.
No, guard of that particular train where the victim has alleged to have traveled.
Sorry, guard of train number. He is given train number. I don't know. Train number is not mentioned.
No, guard
Guard
of.
number. I don't know if it is the same train or the other train because train number is not given by the claimant.
So they, but considering, but is he a guard of Diamond Harbour?
He is a guard not. I was put as a guard of train number 4832 down Sialda, Sialda train, which left Sialda train. He is not that train, but he
Some other Diamond Harbour.
Can you come to page 25? This is the evidence of Devu Maiti.
Statement given before RPF.
Devu Maiti.
Statement given before RPF.
RPF.
Not
Devu Maiti.
in tribal.
Yes, page.
Page 25.
Yes. No, Debu Maiti. Okay, this is the statement to RPF.
Yes. But can you see I will not explain the that. First examination recorded here. Question number 4.
Yes.
Was the railway ticket seized from the question of the deceased person, namely Sachin Kandi, in presence of you? No. No, sir. No any labor degree was seen from the position of deceased person setting and in the presence of me. But when I reached the DRP, Sonarpur office, then they told me that one ticket was found from position of it was not his in his presence. He is relying on the statement of others. You know, kindly come to page 26, the next page. So kindly come to page 26. He is a motorman at Calcutta.
Page 26. Yes.
I on being asked why the Calcutta voluntarily stating how we for in special that actually order of which keep control of Calcutta on 23rd October as motorman of the train number 483 the same day Calcutta railway station at 14:20 hours. They arrived at Nagpur railway station at 15:47 hours. During my duty period, no any incident of knockdown, run over or fall down of the from pain as well as injury. Any person happened at twins. He also supporting this motorman. He didn't notice any accident, neither friend of nor knockdown.
So this person boarded from Sonarpur and the incident is between, as per the claimant's case, boarded from Sonarpur and Subhashgram.
His statement is at page 28. His statement is entirely dependent on hearsay. He has not seen anything personal.
No, this was in the earlier page also.
Devumati is at page 28. My lord is page 28.
Yes.
আগে তো দেবুমাইতি ছিল তো দুবার দিয়েছেন আপনারা ডিআরএম
No, was any question put to him in that where did you sign the seizure list, in police station or in the spot, to this Debumaiti? Debumaiti is the seizure witness. So was any question put that where did you sign the seizure list, in the police station or in the spot?
On their RPF statement, it is established.
Yes.
On their RPF statement, the Bhanu Senapati, who went to the place of occurrence, he himself told in his statement, which is a part of DRM report, page 31, that the ticket was found in his presence and from the pocket of the victim. That is the RPF version also. Page 31 your version. We are not reading page 31, Bhanu Senapati.
Anyway.
Come to page 31. I'm at page 28.
So no question was put that where did you sign the seizure list?
It was not examined in the tribunal.
No, even before authority also, then the mystery could have come out that whether he signed it in the police station or in the spot. Yes. Yes, if Debumaiti signs it in the spot, after that is one thing. Seizure is from the spot. No, Debumaiti has signed the seizure list. So question is whether this question was put that where did you sign the seizure list, in the police station or in the spot? I have signed in the police station. Why has he said that? Where? Which page? Question is, where did he sign the sizzle? That is the pertinent question.
That particular question was never.
Anyway, you delete in your written notes? Yes, any other? Anyway, that you need not any other documents, any other statement?
The page 31 is the statement of Anu Senapati, ASI RPF. That is their internal investigating agency, RPF. What he says, this statement is also part of DRM report. He clearly, page 31, just I am reading the 3 lines. During my duty period, when I was on ground at about 4:30 p.m., an information received from Sialda as well as PC Sonarpur that one incident knockdown occurred in between Sonarpur and Sonarpur. No, that is RPA person is also not the eyewitness. Station master is also not the eyewitness regarding the ticket. After receiving the information, myself, along with Constable G. Vishwas of RPF, both RPF person was there, rushed to the spot and noticed one dead body of unknown male person aged about 35 years was lying near kilometer post number so and so in between Sonarpur and Subhasra. And where GRPF Sonarpur officer SI Santanupar with staff also arrived at the spot. Dead body and nearby area searched by GRPF Sonarpur office and staff and found one railway ticket number so and so from T-shirt pocket of the deceased and one Samsung mobile. This is endorsed by the RPF person himself, who was present at the place of occurrence also.
But no scissor list was prepared by on the spot in my presence. I also conducted local and it will learn that the person knocked down by unknown train. Anyway, that is to be established.
That was not established by their part.
Yes, you have stated that.
He was traveling alone. Why it was not the co-passenger? He could not say that he was how he fell down or he was he not the victim. No documents are there. Nothing. Just on the presumption that he fell down without a claim. Not kindly don't the documents related to the and evidences.
No, you will on the next day, both of you, after considering the entire facts in issue as well as the relevant decisions, submit your written notes of arguments. I am concluding the hearing today and fixing a date for filing written notes of arguments.
Right.
Whatever it is in your written notes, I'll go through that. Yes, record and order. Learned advocates for the parties are present. Heard learned advocates. The hearing is concluded. However, the learned advocates are granted opportunity to file written notes of arguments and relevant judicial decisions. Let this matter appear on 28/7/2026 under the heading to be mentioned. Yes, 28. Under the heading to be mentioned, you file your written notes of arguments. এটাকে ইয়ে করে দেবেন। Huh? The hearing is concluded, but written notes of arguments.
I have already submitted my.
You want to? No, no.
I have
You
already submitted my written notes today. And copy I have also served.
no, no. I have recorded learned advocate. Anyway, better take it back. You so both of you exchange. Better take it back. Yes. On that day you file. Give him advance copy 2-3 days ago. এই ওনার রিটেন নোটসটা দিয়ে দিন, ব্যাক করিয়ে দিন।
My lord.
Seven, both sides are present.
My lord, this was
Yes, so item 14. Yes. Okay, that rectification. না, ওইটা যেটা রেকর্ডে আছে সেটা অনুযায়ী মানে অর্ডার শিটের কস্ট টাইটেলটা হবে।
the balance was refunded to me and
আচ্ছা কি এইটুকু আছে আপন কমপ্লায়েন্স অফ নেসেসারি ফর্মালিটি যেটা আছে, তাহলে ওইখানে খালি ওইটা হবে লার্নেড অ্যাডভোকেট ফর দ্য অ্যাপেলেন্ট ইজ পারমিটেড। দেখি
and I can find the executive case number and order of.
No, I have recorded only upon prior notice to learned advocate for the. Oh, nobody has appeared here. Okay. High Court, Calcutta. Yes, along with accrued interest.
That is the order of the attachment of the bank account of the.
So only that sum was deposited, statutory amount. So how it is executed then?
Stay order they have.
No, no, stay orders are granted, you see, upon deposit of the entire amount. So earlier one
Stated, the stay order was passed on 21/7/2010 and order was
yes 1/7/2000 10/6.
his
Okay, 10/6/10. Earlier, that means interim order was for a limited period. No, on deposit of the statutory amount, interim order or was there for 4 weeks or 5 weeks, whatever it is.
That order was passed on 21/7/2010. Then executing order was passed on 10/6/2010. So this
Oh, that statutory amount order was also passed after execution.
deposit during filing of
Yes.
and we deposit after the order is passed.
Okay. Acha. Retake, huh?
100,000.
Yes, take back. Yes. Yes.
My lord, this appeal of insurer is on the ground of non-involvement of the vehicle. This is the sole ground. There is no cross objection. My lord, awarded sum is secured before my lord's court along with the interest.
Paper books to dekhi.
Thank you so much.
Yes, paper book is not filed.
Yes, it has been. My lord.
এই paper books টা কোথায় এর ওখানে? Oh, oh, Justice Shubhendu Samanto. Justice Shubhendu Samanto. Oh, I thought Justice Probi Samanto. So because this is 2017 matter.
Then, my lord, Mr. Justice Ovi Samanto already retired.
Yes, yes. Okay. Yeah.
My lord, as I said, my lord, it is a death case.
166.
166, my lord. An award of 10 lakhs odd was passed. My lord, there is no dispute with regard to the quantum, my lord. I have secured the sum before your
You
lordship's
have
court.
not challenged the quantum.
No, my lord, I am not challenging quantum. My lord, there is no cross objection as well. So, my lord, the only point, my lord, is to decide, my lord, whether this concerned vehicle was involved in the accident or not. My lord, the allegation is
Yes.
that the deceased victim, my lord,
Yes.
My lord, the deceased was hit by a Maruti car, Maruti Zen, my lord, to be precise, the model. And my lord, I am the insurance company of that Maruti Zen.
Yes.
My case is the deceased was hit by an unknown truck. The truck fled away, and in its place, my lord, Maruti was implanted. My lord, this is the sum and substance of the entire case.
After how many days?
37 days.
Yes.
37. My lord, the accident was on 22nd April 2009. 22nd April 2009. The FIR, my lord, is on 1st of June 2009. I'll straightway, my lord, invite your lordship, my lord, to page 73.
FIR?
On 1st of June 2009. 37 days after the accident, my lord. For the first time.
By the family members or third party?
My lord, by the your lordship will kindly come to page 73, my lord. Is there. I'll just indicate to your lordship.
Yes.
My lord, initially, my lord, when the first written complaint was lodged, my lord, that was lodged on the second day of the accident. That was, my lord, on 23rd April.
By whom?
My lord, this was lodged, my lord, by, this is at page 73, if your lordship kindly comes to.
73 is a representation, actually, because complaint should be lodged in the police station.
My lord, that written complaint is not a part of this paper book. My lord, that is what my difficulty is.
Whatever it is, you see.
Lordship.
Charge sheet is to be submitted on the complaint, and this
Lordship.
is a representation anyway.
Lordship.
The commissioner can also, on the basis of representation, direct investigation.
My lord. My lord, this is your lordship. My lord, if my lord kindly comes to page 73, my lord, to clarify a lot of my lord's
So
queries.
23 for 2009?
70.
Oh, earlier information was given.
23rd April 2009, the first information was given to the police, and it referred to an unknown vehicle. And then, my lord, the date what I had given to your lordship, my lord, on 1st of June 2009, that is after 37 days, this vehicle number, my lord, was given to the police for the first time.
So,
this is reflected from page.
This is clear from the representation itself.
Yes. From page 73, your lordship will
It is
kindly
there.
come. This is there.
And the earlier information given, that is not part of the paper book.
No, that is not part of the paper book, but this records here that the earlier information was given, that was with regard to an unknown vehicle. That is why, my lord, I was praying for your lordship to come to page 73.
Yes.
Is my lord there, page 73, my lord?
Yes.
May I just read, my lord, just to clarify?
Yes.
I, Aditya Singh, aged about 25, son of so and so, by profession businessman, informing you that on 22nd April at about 9:45 p.m. while I was returning home, through Strand Road towards Howrah Bridge, I saw one Maruti Zen car also proceeding just in front of me in the same direction. Suddenly, the Maruti dashed from behind one motorcyclist who was also proceeding at the same direction in front of Zen car. As a result, the motorcyclist fell down and received serious injuries. At that moment, Zen car tried to escape from the accident spot. At once, I write down the number on my left palm, that the number is so and so. Then I go to the injured people, giving my motorcycle for protection to my pillion rider Pankaj. I myself and few nearby people lift him from the roadside. At that moment, he was in full sense. He told us his name is Sikandar. He stayed at GT Road, Howrah. His brother's phone number is so and so. We left him in a taxi and took him to medical college. Then, my lord, second paragraph. After that, I informed the whole matter about accident by above mentioned mobile number to his family, and presently he is admitted at medical college. Afterwards, I went to riding my motorcycle along with my pillion rider. We were out of West Bengal more than 1 month for our transport business. Last week, when we came back and came to learn from a reliable source that the injured person died, police could not trace out the offending vehicle. That is why I'm writing you this letter giving the number of the offending vehicle, that is so and so and so. For the first time, by this, the number of the offending vehicle is brought to the knowledge of the police authorities or to the public at large. This letter, your lordship will kindly see, Milord. On the left, receiving is 9th June 2009.
No, 1st June.
Milord, it is 9. Milord, this rubber stamp is 9. The 9 is not the 9. The circle of 9 is missing. It's 9th June. So, Milord, on 9th June, for the first time, this vehicle, Milord, was brought into the picture. Prior to this, it was an unknown vehicle. Milord, from here the story starts.
No, where in the earlier complaint it is unknown?
Milord, earlier complaint is not a part of this paper. That is why, Milord, I was stumbling. Huh?
Who lodged the earlier complaint?
Sir, earlier complaint bolun page number ta. Page 56, Milord, they say, but your lordship will kindly see page 56, Milord, that complaint is not there. It is, Milord, the FIR is there.
Page 56.
Page 56. Milord, I'll show it to your lordship. Milord, page 56.
It is 23/4/2009.
Yes.
Okay.
Yes.
The accused driver of unknown vehicle.
Lordship, I'm grateful to my lord. Your written complaint is not there. Stateway FIR is there. Your lordship has seen the date, 23rd April 2009.
Lordship will find the brief of the
page
page 60, para 70.
Page 60. No,
Milord,
this is
that's charge sheet. Milord, your
the
lordship.
facts of the case.
Please themselves take care of this.
Okay. So your lordship has seen, Milord, what I stated.
Yes.
On 23rd April, Milord, this written complaint which is missing, the stateway FIR, if it is there, Milord, it speaks about unknown vehicle. And then, Milord, the page 73, for the first time, after 37 days, the vehicle number comes into the picture on record. There is no dispute about these two.
So this is what first information type copy.
Yes, Milord, this is type copy. That's what I was submitting before.
5758 are the type copy.
Yes, 5758 are the type copy. Yes.
Charge sheet type copy is there.
Charge sheet page 59, Milord, it is there.
Okay.
59,
63
it
is the type copy.
Yes, Milord, 61 onwards.
61.
Lordship. 61, 62, 63. 63, Milord, is the page number, para 17 or clause 17's written part. Milord, is at page 63, Milord?
Yes.
Clause 17, Milord, the written, the typewritten part. Yes. Milord, the last 8 lines from the bottom, at the mutation in the middle, Milord. Milord, it is not mutation, at the initiation it should be. At the initiation of the case, offending vehicle was unidentified, but a progress at investigation case on the letter of complaint of the eyewitness since identified the offending vehicle. That is it. As I stated, Milord.
So the vehicle owner filed written statement.
No. Milord, the fact is, on the next date of accident, the FIR was lodged, which speaks
suo motu by the police.
Suo motu by the police, which speaks about, Milord, an unknown vehicle. And 37 days after the date of accident, for the first time, one eyewitness emerges from nowhere and he says that, yes, I was there and I had seen this particular number. This is how, Milord, this vehicle came into the picture. This Maruti Zen. From day 1 to day 36, everything is missing about the vehicle. Yes. Milord, now, Milord, the relevance of this, Milord, your lordship will kindly find from the, Milord, deposition of eyewitness. Page 26, Milord. PW2.
Yes.
I, Aditya so and so. My lord, he is the same person who has lost the FIR. Your lordship will kindly take note of that.
Yes.
My lord, the accident took place, my lord, that is paragraph 2. Then page 27. Paragraph 3, my lord. On the material time of accident, I was returning, my lord, the same fact what he has written in his, my lord, written complaint there. I saw Maruti Zen proceeding in front of me, same direction to south-north, negligent manner, dashed motorcyclist. Motorcycle bearing number so received injuries. At that moment, Zen car tried to fled away from the accident. Somehow I managed to write the number. So, my lord, this is identically, my lord, the same as it was in the written complaint. Then, my lord, your lordship will kindly come to paragraph 4. Thereafter, my lord, the same page 27. Thereafter, I stop at the side of the spot and go to the injured people and lift him at the roadside with the help of the other people and a police. My lord, a policeman was there. At that moment, he was in full sense. The victim was in full sense. Police was there. Victim was in full sense. Eyewitness was there. My lord, the number of local people were there. They all took the victim to the hospital. My lord, the victim told his name is Sikandar. Residential address is so and so. We took him to the medical college for
Victim's
immediate
name is Sikandar Singh. Yes.
lordship. My lord, your lordship will kindly come to the next page. Last para. I informed this accident in writing to the Lal Bazaar on 1/6/2009, which I described in more manner. My lord, till 1/6, everybody, each one of those who were at the spot, my lord, the vehicle number, nobody could say anything, including this eyewitness, so-called eyewitness. Police was also there. He met police because he has seen police there, he himself, this Aditya, this tutored witness, my lord. Did not say anything to anybody. He took the victim to the hospital. That's what he says. Even in hospital, my lord, no record of this offending vehicle. My lord, this is first, my lord, this is absolutely unbelievable story, my lord, as far as eyewitness is concerned. Now, my lord, why I say that victim was hit by a truck. My lord, victim was taken to the hospital. Two gentlemen, two of the doctors of the hospital came up before this court, before this learned tribunal, my lord, and they gave evidence. And they say that what they gathered from the victim, my lord, that victim himself, my lord, he was in full sense. I have made that line, my lord, I have read that line. When he was in hospital, my lord, he said that he was himself driving the motorcycle, victim. My lord, he was hit by a truck. This is what, my lord, the record of the hospital and, my lord, the evidence from the doctors has stated. I'll state to my lord, invite your lordship, my lord, to, my lord, the evidence of OPW2. That is at page number, my lord, 37. If lordship kindly comes to.
37.
Lordship.
Yes.
My name is Rothindranath Chakravarti. My lord, this is a deposition of witness number 2 for defense witness. My name is Rothindranath Chakravarti. Presently, I am attached to Calcutta Medical Research Institute as in charge of medical records department. Is my lord there, my lord? 37.
Yes.
I've been duly authorized by the medical superintendent, so and so. This is a letter of authorization. I know the signature, so and so. My lord, the relevant part, my lord, is at page 38. Page 38, my lord, the first paragraph, last 3-4 lines, my lord. My lord, page 38, first paragraph, last 3-4 lines. The case history. Last 4th line, my lord, first paragraph. The case history from exhibit H1 has been prepared in our hospital. From exhibit H1, it appears that the patient stated that he met with a road traffic accident on 22nd April by a truck while he was driving a motorcycle. By a truck. My lord, this is from the hospital. My lord, this H1 which has been referred to here,
Yes.
Milord, he has been cross-examined.
Yes.
This hospital gentleman. And Milord, here again in page 39, during cross-examination, second para, the patient, page 39, Milord.
Yes.
Second para, the patient died on 23rd. That is the next date of accident, Milord. At about so and so. In the case history from Exhibit 1, it has been written that the patient stated that he met with a road traffic accident on 22nd April with a truck he was riding while he was riding a motorcycle. Patient could not tell the time and place of accident. So far, it appears on the case history. The technical name of head injuries, so and so and so and so. The patient was unconscious. The patient was admitted at 12:07, died at 2 a.m. The patient was unconscious so far as it order dated so and so at 1:25 a.m. The patient was not in a position to record the BP. I brought the documents to place before the so and so doctor's order, so and so. This is this. So, my lord, paragraph 2 says it has been written that the patient stated that he met with a road traffic accident on 22nd with a truck. This is what I was trying to show to your lordship. This exhibit H1, which has been referred to in the the chief as well as in the cross-examination, that is at page number 69. I'll state to your lordship to come to page 69 so that it gets clarified here and now. Page 69, Millard.
Page 69.
Lordship. That exhibit, Millard. Millard, this is CMRI. Your lordship will kindly see, Millard, at the bottom where the box ends. How did the injury occur? That is the typed part. Millard, after
is it from the patient or from the patient's party?
Millard, this is written by this doctor, this Rothindranath Mukherjee, who has come to give an evidence. Yes.
History is not from the patient, but the persons who have brought the patients.
Millard, this
case history.
Millard, this case history, the gentleman, the OPW2 says that I have heard it and I have spoken to the patient himself.
But he was in unconscious condition.
Millard, he says that patient became unconscious at 1:25.
Okay.
He was there at 12:07. So he was at least for 1 hour, 20 minutes, Millard, he was conscious there.
Yes, page 68.
Page 69, Millard.
Page 69.
How did, Millard, when the box ends at the right bottom in the middle of it, Millard, how did the injury occur? It is a type part, Millard. Bottom right at the end of the boxes, Millard. How did the injury occur? Then handwritten part is patient was driving his motorcycle while he collided with a truck. Has my lord seen that, Millard?
Yes, yes.
And then, Millard, just below that, the signature is of Rothin Mukherjee. This gentleman, Millard, is the one who gave evidence, who has recorded this, who went to the tribunal and gave evidence.
Okay, this is, you see, 23/4/2009 is the date of death.
Yes.
And at the date of admission, 22/4/2009.
Yes, Millard. Yes.
That is
Millard, he was admitted on
2009
at 12:07 a.m.
Yes. So this is the report. That is the cause of the death. Okay.
Yes.
Cause of the death will be confirmed after
postmortem.
Okay. This is the cause of the injury.
Yes.
Manner of death, accident. Okay. This is the report prepared at the time of death.
Millard, this is the report prepared, Millard, by the person
after
death, Millard, or maybe, Millard, this is the police case reference.
No, 23/4/2009. That is the date of death.
Millard, he was admitted on 23/4/29 itself. Your lordship will kindly see page
23 or
38.
22?
Millard, your lordship will kindly come to page 38.
38.
Yes. First para.
Yes.
That is the evidence of same gentleman, Rothin Mukherjee, of the CMRI. Millard, first paragraph, Millard, 1, 2, 3, 4, 5, 6, 7th, 8th line from the bottom. He was admitted.
An accident took place on the same date.
On 22nd at night.
Okay, 22nd.
Yes, my lord.
And died on 23rd itself.
23rd, my lord, immediately thereafter. After, my lord, around 2 o'clock or whatever it was. So, my lord, he was admitted on 23rd April at 12:07 a.m.
Patient died on 23/4/2009 at 2 a.m.
Yes.
And
so he was in the hospital, Miller, he was alive for nearly 2 hours, roughly.
And how did the patient, this victim's family, come to know about accident as per PW1?
Milord, PW1, Milord, I had shown to your lordship, Milord.
Oh, that is the witness.
Yes.
PW2 is the witness.
Yes, PW1 is at page 18, page 18.
Yes.
Milord, your lordship will kindly come to page 19. Milord, the lady who has come up as PW1, she is the widow of the deceased, Milord.
But yes, from where did he? Yes.
Milord, page
We have
90.
heard from Jitendra Singh, elder
Lordship.
brother, who received phone calls about the mode and manner of accident.
Lordship. And just prior to that, Milord, the paragraph 4, accident on 22nd at 9:45 at night.
Okay.
So, Milord, 9:45.
Anyway,
Yes, Milord.
admitted at 12 p.m.
Admitted at 12
p.m. or whatever.
Yes, Milord, died around 2 o'clock. And hospital record immediately on admission from the victim, what he gathered, Milord, the gentleman from the hospital
Anyway,
staff.
this time may vary. 21.45, it may be 11 or something.
Milord, maybe 11, Milord. We do not know. What is there on record, Milord? I'm just showing to Lordship, Milord.
Okay, and the cross-examination?
Milord,
this person, this lady came to know from the victim's brother.
Yes.
About after receiving phone calls.
Yes, after receiving phone calls.
Yes. Now, with regard to this cross-examination.
Milord, cross-examination of lady PW1.
PW1.
Milord, there won't be any dispute with cross-examination because she was not at the spot.
No, from whom she has received?
Lordship.
Because you see, this person PW2 said that he has informed.
Yes, he has informed
family members.
Yes. Milord, maybe he has informed the brother, and then the brother might have informed Milord his sister-in-law. Milord, there is nothing with regard to Milord further confusion. Milord, what I am on till 37th day, this vehicle number was not in picture.
In another case, I have come across a bedhead ticket where from the person who brought the patient,
Lordship,
statement was recorded because they are in a position to say who is there. But here, no person who brought the patient stated anything.
Milord, here the further evidence is that the victim himself has stated this. I'll show that also to your lordship.
You see, after 1 hour became unconscious and died.
Milord, the hospital says that we have got it from victim.
Anyway, but not from the victim's family or members.
No, nothing. And learned judge has dealt with this issue, Milord. What is in my lord's mind that how can Milord victim can himself say?
But hospital, other cases, you see, I've seen from the persons who brought
yes
from the patient's family, patient party.
Yes,
because
but
patient
here
is there.
My lord is correct.
Doctor will ask the doctor will
This
talk
is
with
what
the patient's
normally
party.
happens. This is what normally happens.
In normal illness also.
Yes.
The doctor will ask what happened.
In this case, the evidence is this truck.
Because you see, dying declarations are something where the victim who has been assaulted or this thing administered poison, he can say it's good in dying declaration. That can be a good piece of evidence.
Milord, this has been treated as the dying declaration, and learned tribunal judge has said that victim was not in his senses, so I will not consider this dying declaration to be correct.
Anyway, let us.
Learned tribunal judge has gone to that extent to disbelieve this dying declaration.
Now, another thing is this: so far the statement is concerned, receiving the information.
Yes,
that is from the brother of the victim.
By the widow received.
From the brother of the victim.
From the brother of the victim. Milord, we are not on that. Milord, we are only on the point that, Milord, whether this Maruti was there or whether the truck was there. Maruti, I am the insurance company. So, Milord, the widow's evidence, Milord, I have shown to your lordship. That is, Milord, would not be related much to this particular. It would not be helping out the cause of either of the parties. Lord, I've shown the eyewitness, how the eyewitness, Lord, was telling lies before the court, because police was there and police was unaware of anything, and police came to know after this eyewitness came out of his sojourn, Lord, after 1.5 months and 37 days, and then he comes back to the police and says, now I will tell you the accident vehicle number, which I had seen before 37 days. Now, Lord, I have shown your Lordship, Lord, the evidence of this CMRI doctor, the record keeper. Then your Lordship will kindly also come, Lord, to Lord, doctors of CMRI who treated this patient OPW3. Lord, that is at page 35. Lord, I had shown OPW2. Lord, now it is OPW3 at page 35.
Yes. Yes.
My name is Dr. Rothin Mukherjee. My occupation is doctor. I am Dr. Rothin Mukherjee, now attached to CMRI, Kolkata, as ICU medical officer. On 22nd and 23rd, I was in the same place and in the same post. On 23rd, one Sikandar was admitted to our hospital at ICU at 12:10 a.m. You know, timings are all matching, all correct. I have examined myself, Sikandar. The case history form was written by myself and my own handwriting. Exhibit H1 is shown to the witness. It bears my signature also. At the time of admission to the ICU, the patient was conscious.
And you see, with this particular patient, whether he spoke in Hindi or Bengali, that also it's not clear. It's
No, it is immaterial. The patient was conscious and this doctor was
whether he spoke in Hindi or whether
it is material, whether it spoke in Hindi or Bengali, on in Odia or on.
Because you see,
Yes.
these persons recording, these are all Bengali persons. And this
But he's a doctor. He's an ICU head.
Right. And this victim is not a Bengali. So
Maybe.
So in Hindi, what he stated, it is very difficult to ascertain.
My lord, is
why you see.
My lord, is what my lord is trying to infer, that a doctor would not understand the difference between a truck and a Maruti.
No question of truck and Maruti. What he said, somewhere I find dashing. In this case, it is collision.
Yes, collision or dashing. My lord, the particular is the vehicle, whether it was a truck or a Maruti.
Collision, he can see. But if it is dashed from behind, if he falls, it is difficult to see.
But my lord, this is what the patient has said. What am I going to do here, my lord? Your lordship will kindly understand. My lord, we are here in this courtroom. In this courtroom, we are on the basis of the record. The doctor at ICU, who is in the CMRI, he says that he spoke to the patient and patient said that the truck was involved. So, my lord, how do we here will say that no, instead of truck, it might be another vehicle? None of us here, my lord, are in a position to, my lord, to discard this. The person who was treating the patient at 12:10 at night in the ICU, the doctor, he says, he comes to the court and he stands in the witness box and he says that, yes, patient told me that he was hit by a truck. But how can we discard that?
Truck and lorry is the same.
Yes, truck and lorry. What is written is, it is written truck.
Whether he said truck or lorry, that we don't know.
Why shall we know, because he said truck. The doctor has written truck. He comes to the court and says, I have written truck.
More or less, you see, patients may say many things. Doctors write in their own way.
But doctor has come to the court.
Very well.
He stood in the witness box.
Let us see that.
My lord is absolutely correct. Doctor would write in the own way.
You
but
may say many things.
But
doctor will write
but
in
the
their
truck
way.
is not too simplified a term to give any other twisted
What
meaning.
Say, truck, lorry, gadi. We don't know.
But when the doctor
truck,
has
lorry, gaddi, whatever is.
Whatever, we should not assume here.
Yes, that is.
Doctor has written truck and he said that I have been told by the patient that he was hit by the truck. I am standing in the witness box and I am telling what I have written in there. I spoke to the person.
The doctor's version should be believed or that PW2 should be believed?
If PW2, my lord, is the eyewitness.
Who should be believed? That is the thing.
Absolutely correct. Eyewitness comes up and says that when the accident took place, I was there, police was there, there were so many, my lord, witnesses. Nobody at that point of time, including police, knew about the number of the vehicle. Eyewitness comes after 37 days. He said, I went outside, and after 37 days, he remembers that there was an accident 37 days before. Now, today, I should go to the police and give the number of the vehicle. How did he know, my lord, that the number was already not there, whether it was there or not? And if the police was on the spot, why did police did not take the number when the police was on the spot? And the doctors who treated the patient at the time of his death, he says, patient told me it was struck. Why shall I be disbelieving that?
Let us see. This is the second doctor.
Yes, my lord. My lord, it goes further, my lord. It bears my signature also. At the time of admission to the ICU, the patient was conscious. But this is the doctor, my lord, of CMRI, not of any ordinary nursing home, my lord, who can be, my lord. I had talked with him. My lord, will kindly see. He says the patient spoke to me and said that it was a truck. I was told by the patient himself that he met with a road traffic accident in evening on 22/4/29 by a truck. Your lordship will kindly make a mark of this. I have noted the statement of the patient in my own handwriting. This, my lord, page 69, my lord, refers to this OPW3. I'm sorry, my lord, I said it OPW2, it refers to OPW3.
Yes.
My lord, Exhibit F is shown to the witness that this death certificate of Sikandar was also written by me in my own handwriting. He died on 23/4 at 2 a.m. It also bears my signature. Whatever I have stated today are all true. Cross-examination is there. In the cross-examination, second paragraph, at the relevant point of time, I was the only person present near the patient. I have recorded his statement and nobody except myself heard the statement of the patient. Not a fact that at the relevant point of time, the patient was not in a position to give any statement. He's so clear that patient was conscious, patient was in a position to give a statement. I have myself in the middle ICU written down what patient is stated, and he stated that he was hit by a truck. And there should not be any reason to disbelieve a doctor of CMRI who comes from ICU or from his hospital and stands in the witness box and give evidence and stands the rigors of cross-examination as well. And he sticks to his point, my lord. He has got no personal interest in this case. At least he is not, my lord, that Dr. Binoti Das or Dr. P.K. Mondal who keeps on throwing, my lord, these medical certificates. He's a doctor of CMRI and the one who was in charge of ICU at that particular point of time. And he treated the patient. My lord, these are two issues, my lord. Two evidences, my lord, which I rely upon heavily, that the patient or this victim was hit by a truck. He was not hit by the Maruti as alleged. The entire case of the claimants, my lord, that he was hit by the Maruti is based on that eyewitness's statement, who I have shown to your lordship, my lord, is not believable. I rely upon these two statements of the my lord staff as well as my lord, the doctor of CMRI who had personally spoken to the victim, who had written, my lord, their notes herein. My lord, the award of learned tribunal, my lord, while dealing with this particular issue,
yes, page.
My lord, the award starts at page 78.
Yes.
My lord, straightway, my lord, I invite how the learned tribunal judge, my lord, has disbelieved this doctor's statement. My lord, it's at page 85.
Yes.
Page 85, bottom, my lord, it refers to charge sheet. The last paragraph of page 85. Then the next paragraph, I'll show to lordship. After a full-fledged, my lord, is there, my lord? My lord, is there, my lord, after a full-fledged investigation, charge sheet was submitted. It was finding of the investigation that the driver of the offending Zen caused the accident. So we are to choose between one statement to be made by the victim with a 0 blood pressure and severe injuries who died within 2 hours of making alleged statement, and the statement of eyewitnesses and charge sheet submitted after through investigation. My lord, next paragraph, my lord, which is the finding. Page 86. Second paragraph, in view of the admitted critical physical condition of the victim and the evidence of eyewitness and the charge sheet have been found, no reliance can be placed on alleged statement of victim, and there is no reason not to trust or act upon the charge sheet and the statement of eyewitness whose credibility could not be shaken during his cross-examination. This is the sum and substance. My lord, the learned tribunal just says that forget about doctor. I know more than him. Doctor might have spoken to him personally, but patient was not fit enough, or rather he was critical enough to not to give him proper answer. Therefore, I will not believe the doctor. I would rather believe the eyewitness who after 37 days come back from nowhere and who says, my lord, before the Thana that yes, this was the vehicle involved. My lord, how can, my lord, the learned tribunal judge go over and above the statement of a doctor who has spoken to the person in ICU?
Not ICU, emergency.
Emergency, yes, my lord. He was in charge of ICU. He was in emergency.
He is taken to emergency from.
Yes, yes.
There
yes.
he spoke.
And he was treating this gentleman, the deceased. The learned tribunal just says that no, zero, my lord, this zero blood pressure, my lord, it is a situation when the person is already dead. When somebody is in zero blood pressure, my lord, he cannot speak, then he is dead. It is not a case of zero blood pressure was down. Definitely, my lord, the person met with an accident. So he says that it was a zero blood pressure case. So the patient, my lord, was incoherent. Patient was not in his proper senses. So he wouldn't have been saying the proper things to the doctor. And the doctor says he was conscious. He was in a position to speak. I've spoken to him personally, and he said that the truck was involved. So the doctor's testimony, learned tribunal judge, on his wings, with the greatest of respect, has discarded and says that no, I will not believe the doctor. I will not believe the hospital staff. The doctor himself, in his own handwriting, writes this, who has got no interest in this case. His testimony is disbelieved, and the Maruti Zen is considered to be on the basis of that eyewitness, alleged eyewitness, the tutored eyewitness, is held to be correct. Because the ball has started rolling after 37 days. Till 37 day blank, from 37 days, this letter, the subsequent, the second FIR or whatever it is, then charge sheet, then seizure, and then, the eyewitness in court. And I have brought in the doctors, one doctor, the staff of the medical emergency, and the hospital is of repute. It cannot be thrown away like this. The doctors are of repute. They are not simple, those who keep on issuing them medical certificates. So, on this basis, I say the truck was involved, which was subsequently, the Maruti was subsequently implanted with a very clear-cut motive. Supreme Court's judgment, on this implantation, my lord, is very clear, Sayyid Safi, that how these are happening, my lord. One of the greatest frauds in the country which are happening.
Apart from this involvement, have you challenged any quantum or something?
No, my lord, quantum, I said there is no dispute with regard to the quantum. Your lordship will kindly not touch that. Only, my lord, this is the issue, whether it was involved or not.
Yes, we have to consider the decision of the judge as well as the evidence.
My lord, my lord. This
Yes,
is my lord. This is the sum and substance. I'm grateful to your lordship.
Before submitting, my lord, I am referring one judgment.
No, you submit of the facts, thereafter you decide whether you justify the decision of the tribunal or not.
I don't want to do just. Lordship. My learned friend, my lord, filed this appeal, relying the arrest statement of the doctor. What raised dispute in regard to, according to the eyewitness, Maruti Zen dashed behind the back of the victim, and consequently he sustained injury and thereafter. According to my learned friend, a truck crash. No, my lord. The accident took place on 22nd April 2009 at 21:45 hours. 9:45. Well, in the year, Lordship may remember, in the year 2009, at place of occurrence by the scanning, Lordship may remember, prior to 10 p.m., the movement of truck was restricted. As such, my respectful submission before you. At 9:45 p.m., there was no truck flying on the stand road. Lordship may remember.
Anyway, these are not on record.
Yes. No, my lord. The insurance company, my lord, in their written statement at paragraph 4, written statement of the insurance company.
You see, vehicle owner did not file any written statement. Page? Yes, page? Yes.
6 to 30. I'm coming here. At para 4, the opposite party admits that the interest of Santosh Kumar Singh is still number WB 16H-4181 within bracket Maruti Jain was covered at the very real time under the policy.
No, that's a different issue. See, after the evidence is adduced by the doctor, okay, what finding should be arrived at?
But after the evidence of the doctor,
So this is with regard to the vehicle's insurance.
vehicle insurance.
Yes.
Vehicle is covered by the insurance company.
That is why I am here. Your Lordship will kindly come paragraph 12. I have denied the involvement. It's specifically paragraph 12.
Yes.
Page 9.
FIR.
Yes.
First FIR. So, FIR, initial FIR was lodged by the police person. And he actually, police performing their duties. What accident took place? And after hearing the problem, my lord, police rush. And in the meantime, my lord, the vehicle fled. My lord, as such, the police authority, my lord, initially lost that FIR, my lord, stating that the vehicle is RID. And thereafter, my lord, the eyewitness who got this victim at the hospital, my lord, was a complaint.
That is after 1 month.
After 1 month, and the delay for such lodging, my lord, has been explained. It is correct that the delay in lodging the FIR is fatal in the light of the criminal jurisprudence. But here, my lord, the complainant, my lord, explained why he could not lodge the FIR in time. Lordship, kindly come at the complaint of opportunity.
Page 73, sir. হ্যাঁ 73 তে চলে যান, ওইখানে কমপ্লেইন আছে।
72. The Aditya Singh, aged about 25 years, son of Sri Arun Kumar Singh, residing at 21/1 Ovalpuho Road, PS Bali, post office Velua, Howrah, by profession a businessman within bracket transport, informing you that on 12/4/2009 at about 9:45 p.m. while I was returning home, riding my motorcycle along with one pillion rider, namely Ankit Singh, aged about 22, son of such and such, residing at such and such, Bali, Howrah, through Stand Road towards Howrah Beach, and when reached in front of 38 Stand Road, I see one Maruti Jain car also proceeding just in front of me with same direction. Suddenly, the Maruti car dashed from behind one motorcycle who was also proceeding at the same direction in front of Maruti Jain. As a result, the Maruti Jain fell down, the motorcycle fell down on the road with his motorcycle and received serious bleeding injury on his body. At that moment, Jane car tried to escape from the accident spot. It is very important, Bharat. What I have submitted in earlier occasion. A police person is performing duty here. And the accident took place at near our court number once. In this, during this period, after hearing the noise, the public noise, these gentlemen arrived there. No, at once, at the moment the Maruti Jan tried to escape from the accident spot, at once I write down the number of my left palm. That is WB such and such. When I go to the injured people, giving my motorcycle for protection of my pillion rider Pankaj Singh, I myself and few neighbor people lived him by road such and such. Now, my lord, what the yes, at the initial stage, my lord, last paragraph, we left him at the taxi towards medical college for immediate treatment. It is the first paragraph end, my lord. After that, I informed the whole matter about the accident by above mentioned mobile number to his family, and presently he is admitted at medical college. So far, the knowledge of this complainant is concerned, my lord, he admitted him at the medical college and he is still there. Afterwards, I went my residence, riding my motorcycle along with the pillion rider. We were out of the West Bengal. Here is the delay. We were out of West Bengal more than 1 month for our transport business. Last week, when we came back and came to learn from a reliable source that the injured person died and the police could not trace the offending vehicle. That is why I am writing you this letter, giving the number of my offending vehicle, that is such and such.
My lord, he says that the victim is presently at the medical college. Your lordship will kindly see the fund.
Yes, he.
Is it, my lord? Is it? But what is this happening, my lord?
He brought this initially. He brought him at the medical college. Thereafter, my lord, he has been shifted at CMRI. Now, my lord, I am coming to the evidence of the doctor.
After 37 days, victim died on the same day, and he says that he is presently at the medical college.
Delay has been.
Yes, page. Which page?
Yes, what I am reading.
No, which page you are relying?
I am relying on 73A.
Now, that I have read. Any other evidence?
Yes. I should have said. 26 to 31.
Page 26, eyewitness.
Yes, 26.
Evidence, eyewitness. But I am coming at page 22, 27.
Yes.
Paragraph 3. On the material date and time of the accident, I was returning home. Same thing, what they have stated in the complaint, same thing has been mentioned, no deviation. On the material date and time, on the time of the accident, I was returning home, riding my motorcycle along with pylon rider namely such and such through Stand Road towards Howrah. I see one Maruti car bearing registration number such and such also proceeding in front of me in same direction from south to north in a rash and negligent manner. And suddenly, the Maruti jail car dashed one motorcycle from its behind, who was also proceeding at the same direction in front of Maruti jail car among other vehicles, and as a result, the motorcycle fell down on the road with his motorcycle bearing registration number such and such and received serious bleeding injury on his body. At that moment, the jail car tried to flee away from the accident spot. Somehow, I managed to write the number of the offending Maruti vehicle in my left hand pocket. And thereafter, my lord, paragraph 6. I informed about this accident in writing to the Lal Bazar Police Department dated 1/6/2009, in which I described the mode, manner, date, time of the accident and the registration number of the offending Maruti jail car bearing number.
Okay, in the evidence he stated he got him admitted to the medical college. But this, is it CMRI? No, medical college, which medical college?
But I don't know which medical college.
No, he stated that medical college.
Yes.
But this doctor is,
He has been treated at CMRI.
okay, Calcutta Medical Research Institute.
Yes, this near Alipur Zoo.
And this person stated that
medical college.
Medical college. But not stated Calcutta Medical College or.
No, not CMRI, Calcutta Medical Research Institute. It's absolutely
But
different.
this person is stating admitted to Calcutta Medical College.
Yes.
Yes, Calcutta Medical College. Lawsuit gave it on para 56.
Para?
Para 56. Para 56.
Page 56, sir.
FIR. Page 56.
Yes, negligent.
Para 12. Type copy.
Para 12. Yes.
Type copy is there.
Remove to MCH. Bleeding your leg and remove to MCH. Medical College and Hospital. Very primarily and hence admitted to CMRI. Okay, first medical college, thereafter.
Thereafter CMRI. No, my lord. Now I am coming with the evidence of the doctor which my learned friend relies.
Page 57.
Yes. 37. 37 it starts. My learned friend
Yes.
my lord, My learned friend told me the statement of the universe.
Yes.
But my lord, my learned friend was silent about the prophet.
Yes.
It is at page 36.
Page
Page 36.
36. No, not 36. 36 is the evidence. Yes.
The patient not say to me the place and exact time of the accident. A person, my lord, who is unable to say the place and exact time of the accident, he is saying that a truck dashed me from my back. It is curious, my lord. I'm surprised. At the relevant point of time of admission of the patient had no blood pressure. But blood pressure was nil. How doctor recorded that he was conscious at the time of admission, and just 2 hours thereafter patient expired. My respectful submission before your lordship is this, that at the time of recording this statement, he was in coma.
Okay, now another thing is this. Did this PW2 take him to CMRI? That is the thing.
No,
No, no.
he brought the patient at the medical college, and thereafter he left Calcutta for his
Thereafter, he went to home.
thereafter he left for Calcutta for his business.
No, no. At night, he did not leave Calcutta. He went home.
Yes.
Yes.
Thereafter he
So he did not admit him to CMRI. So CMRI, who took him, that we don't know.
victim thereafter got released the
No, no, not released. Definitely from Calcutta Medical, he was transferred to this place. From Calcutta Medical College, he was transferred to this CMRI. You see, accident is not disputed, admission to medical college not disputed, nothing.
Nothing.
Save and accept that vehicle number.
Grateful to your lordship.
Yes.
Obliged to my lord.
Nothing. Definitely he was taken to both the
Yes,
hospitals.
yes, yes.
Admission.
But who admitted? That means these persons were not there. After getting him to admitted to medical college, he was shifted to CMRI. There, I think there was no other persons.
lordship can't see this.
My lord, the family members were informed.
No, family members may be informed.
Family members were informed from the spot of accident.
Yes.
He called them up.
Yes.
They must have gone to the my lord medical college, and from there they might have taken. But that
Unless some expenditure is incurred,
lordship,
unless the expenditure is incurred,
lordship,
you see,
lordship.
why CMRI will admit? Because it's a private institute.
My lord, that evidence part is not here, but the fact is he was taken to my lord medical college,
then shifted to
CMRI, and my lord, this so-called eyewitness says that I have
their role is up to medical college.
My lord, that's what he says.
They are not thereafter.
Not thereafter. It doesn't say anything else.
Anyway.
And CMRI suddenly come into the picture, and doctor adduced his evidence.
It is suddenly, my lord. He was taken to CMRI. He was admitted there suddenly.
Lordship,
Person died at CMRI.
I want this
Decision, yes, give it.
I'm relying paragraph 50. Bimola Devi, আপনি জানেন তো?
Yes, paragraph 15.
Paragraph 15.
Yes.
In a situation of the nature, tribunal.
No, para 15. Yes. We find that the tribunal. Yes. No, para 15 you are relying. Yes.
in a situation of this nature.
Where? Para 15 is different. Para 15 is we find, yes, this is what National Insurance Company Limited. Okay,
Vimola versus Himachal Road Transport Company.
no, you are relying upon decision of this court by Justice Dipankar Dotto. Putul Boksh.
Sorry. It is Supreme Court judgment.
Yes.
Same thing, same observation has been.
Yes. What is the? Yes, which page?
Here also para 15.
Okay, para 15. Yes, in a situation.
In a situation of this nature, the tribunal has rightly taken a holistic view of the matter. It was necessary to be borne in mind the strict group of accident caused by a particular bus in a particular manner may not be possible to be done by the claimants. The claimants were merely to establish their case on the custody of preponderance of probability. The standard of proof beyond reasonable doubt should not have been applied. For the said purpose, the High Court would have taken into consideration the respective stories set forth by both matters. Malad, in a motor accident case, Malad, this observation has been given by the apex court and same view has been taken by divisional bench
By Justice Dotto, presided.
by Justice Dotto. The same paragraph.
Yes, anything else?
Malad,
Milord, how long this fraudulent implantation would go on, Milord?
Yes.
Milord, how long these fraudulent implantations would go on, Milord? I
That
asked
is
this
why I
question to
stated that regarding taking to hospital, transferring there, everything, whether the number is properly recorded. That is the thing. Accident is not disputed.
Yes, only the way implantation, Milord. I'm only disputing that.
Yes. Anything?
Malad, so these are then I just file one.
No, it's not necessary. Yes, so I conclude.
Yes, Milord.
Yes, record an order. Learned advocates for the parties are present. Heard learned advocates. Hearing is concluded. Let this matter appear for judgment on 28/7/2026.